Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, be seated, please. It's good to have counsel here. This is our first sitting in almost 2 years, and I don't know if it's an improvement or not with the various mutations going around, but I must say it's nice to have you here from our point of view, and I think you'll appreciate oral argument better this way than on television, so to speak. All right, we'll hear the first case, MacIver versus Bridgestone America. Mr. Hayes.
Thank you. May it please the court. My name is Mark Hayes. I represent the plaintiff here, Ms. MacIver, in her claim. Ms. MacIver was the victim of years-long harassment when her coworkers repeatedly sabotaged her work machine. That sabotage gave rise to two Title VII claims that are before this court today. The harassment itself led to a hostile work environment claim. And when Bridgestone tried to basically discipline Ms. MacIver out of making those complaints repeatedly, it gave rise to a retaliation claim. On the hostile work environment claim, Bridgestone really only talks about one of those elements, the severity element. And Bridgestone's analysis is flawed because it only looks at what I might call the facially racial events from the first part of this case. Now, those events are pretty severe. Just to sum them up, a coworker of Ms. MacIver's, Mr. Hawley, hung a noose on the machine of an African-American worker in 2006. He bragged about it openly to other people in the section that he and Ms. MacIver worked in. There was no discipline for Mr. Wheeler, who took the blame for it, but wasn't disciplined. Then, as if one noose wasn't enough, there was a second noose, this one fashioned around a monkey, which of course is also a racial figure, hung on someone's machine again. And then if one monkey isn't enough, there was a second monkey, this one without eyes, that was hung on the machine. And then, just as kind of a bonus, I guess, there was some graffiti for Trayvon Martin / President Obama that had exaggerated figures for African Americans. There was a Confederate flag, the words "Justice Served," which I guess celebrated Trayvon Martin's killing that was found in the bathroom. So those are all just kind of around Ms. MacIver, but we also had some egregiously racist behavior being targeted directly at her. Most specifically, when she comes over in 2007, Mr. Hawley stated the following, quote, "We were doing fine without Black people on this crew." And then a year later blamed Ms. MacIver was, quote, "the reason why Black people got to come to this crew." And he also directly told Ms. MacIver, "Hey, you know that noose that was hung on the machine? That was me." So all of that is the egregious stuff. Bridgestone can't get around that. So its only argument is to try to distance itself from it temporally. And the way it does that is the way this case evolves, what we might call the next phase of the case. The events are not facially racist. And by that, I mean, if you look at them in isolation, you would say, I don't know if this is racist or not, but there's this series of sabotage, which begins within the era of all that facially racist material and then continues all the way to the forced transfer. So the first link in that chain.
When you say sabotage, that's a pretty loaded term. Correct me if I'm wrong. I understood that there were two ways that her machine was being affected. One was the settings she had were changed. And number two, there was grease on the sensors at least a couple of times. But there was no destruction of the machine, or it was basically she had to go through all the settings again. Is that, do I understand correctly on that?
That's right. Those are the two main types. Three times for the dirt and grease, but then repeatedly with the settings being changed. And that was actually quantified in Bridgestone coming up with hard data about these setup delays. And the reason that those were so significant, if they had just destroyed a machine, then it would have stopped, right? I mean, like she would just move to another machine. But in constantly changing the settings each morning, her setup time is always increased. And so severity is looking at two big factors for severity are pervasiveness. So it happens just over years. You know, she makes a complaint in 2008 and sees someone running from her machine. And that's where she first makes that connection. The sabotage is based in all this stuff and being targeted at.
Can I ask you a little bit about the 2008 tampering that we're describing? So when I read your complaint, it doesn't refer to anything in 2008, right? It has an allegation back in 2006, but nothing about tampering. All the allegations related to Ms. McIver start in 2016 and later, right? That's the substance of the allegations in the complaint start in 2016. And then when I read, your responses to the summary judgment motion, you say that, she only began being harassed following her second EEOC charge, right? Which is 2014. And you say in the same filing to the court that she hadn't accused any coworkers of tampering with her machines until 2013, right? So before the district court, the argument in the complaint and the briefing from your client all talked about tampering at least later than 2013 and disavowed, it seems to me, tampering before that time. And the district court seemed to rely on that in its ruling in talking about the divergence. But you come to our court and say, based on what seems like an ambiguous statement, at least to me, from her deposition, and say, no, there was tampering in 2008 as well. Can you make the 2008 claim given the nature of the complaint and the claims that you made to the district court in your summary judgment briefing?
I think the 2008 event, and just for reference, I'll direct this court to page 179 of the joint appendix, and there's another relevant page, 179 and 193. Those are kind of the ones read together, which is the 2008, 179.
And if you read them together, you might conclude that there was tampering in 2008, but it's not clear to me. But take that aside, assuming you had a clear statement somewhere in the record, it's not in your complaint. It was disavowed in your opposition to summary judgment, right? It didn't happen before 2013 is the claim you make to the court. And the district court relies on that in issuing its ruling. And then you come to us and say, no, our theory is a different theory now. It's not that. It's that, oh no, this goes back to 2008. And that's how we connect these obviously horrific events in the past to the current situation we find ourselves in.
I think the ambiguity, Your Honor, is in, she's being accused of not being a good teammate because she's, calling out specific people. And I think the ambiguity is that is whether or not she's calling out specific people or whether she's lodging more general complaints. And maybe it wasn't, artfully put, but I think that even though she's saying the 2008, I don't know if she would say if we were in front of a jury, if she would say, well, that's not the degree that I would call rises to the level of sabotage, but it doesn't have to be the sabotage itself. It's just the informing act that explains how a reasonable jury would connect those dots.
But you said in the brief, and part of this is like not whether she could do this, but my concern is the theory of your case has changed on appeal. And we don't typically let that happen, right? You don't get to try the case below on one theory and then come to us and say, oh, actually, in order to explain why the district court's wrong, let us give you a different theory, right? Because you say that your client hadn't accused any coworker of tampering with her machine until 2013, right? And so to me, that's the claim that you're making. And not that she was making those accusations or that there was tampering in 2008. And so that's the trouble. I'm just trying to understand how I can ignore how you presented the case. And as obviously, I'm not talking about you personally, but your client, how you presented the case to the district court, and then how that's different from how you're presenting the case to us. And so even if we agree with your presentation, can we ignore what what the case was presented to the district court? I mean, we're evaluating the arguments that you made to the district court, not the new ones you're making now, right?
Right. So I would say, just so that I don't have any time to talk about anything else, I would say, I think the ambiguity is about whether she's identifying someone specifically and whether that would rise to the level of what she would call sabotage or not, or whether it's just a messing with that then informs later things that happen. But setting that aside, let's say we just set that to the side. What is the context of when she's making the complaints in 2013 and then up through her conversation with Ms. Hauser in 2016, and then when she meets with Mr. Dar in 2017 and Mr. Moeller in 2017? What's the context there? Well, she knows that machines are being messed with without, with abandon, really, of African-American workers. And anyone, even without the 2008, let's just take it off.
What's the allegation? You said African-American workers. Where's the information in the record that another African-American's machine was being messed with?
She was the only one for a while, right?
So,
Sir, wasn't
Yes.
she the only African-American for a while?
she was the only African-American for a while. She comes over in 2007, and then a second African-American comes over, but those are within the MTS section. Of course, it's a terribly large company. So some of these instances, like the noose and the monkeys.
When did this other African-American arrive?
I can't tell you the exact date. It was a couple years later that this, and I know it was a male, came into her particular section. So she started.
About 2015, you're saying then?
That would be a good estimate. And I'm sorry, Your Honor.
It's not in the record though?
I know it's not in the records specifically. I know it's not.
But it has to be like 2008, 2009, because that's when you allege the comment that she's the reason we have African-Americans in this section, right?
Right. I mean, that would be an inference that a jury could certainly draw, that because of that statement that was contemporaneous with somebody else coming or maybe about to come. So I think that's a good way. But regardless of the 2008, when you look back at the—
Can you go back to the question I asked before Judge Motz's question? You said that they knew that African-American workers, plural, machines were being tampered with. And I just didn't see that in the record. I'm just curious, what was the suggestion or evidence that you'd point to that there was evidence or allegation put forward by your client that there was another example? I'm not sure exactly why it matters. You just made the claim that there were multiple workers whose machines were being tampered with. I'm just trying to understand where that comes from.
I know that of the original noose for Mr. Hawley and the two monkeys, I know that at least one of those was an African-American worker, but I'm sorry, I don't have the site for you.
No, the question is, you talked about tampering with the machines.
Right.
One of the big challenges in this case is to link the tampering to the plant conditions in 2006 or 2007. And I think these questions are probing whether there is enough there. And if there is evidence that other African-American machines were being tampered with, that's important evidence, but this is the first time I heard it right here in the courtroom.
So, Your Honor, maybe I'm using the word tampering broadly. When I say tampering, I'm using that when someone does something to their machine, which I would include hanging the nooses on, hanging the monkeys on. I'm not saying that there is no other evidence, to my knowledge, of other setting changes or depositing grease and dirt.
You mean that any other employee was subject to them? But of course, is that what you're saying?
I'm saying I'm not aware of any record evidence that any other settings or that sort of thing were ever changed.
For any other employee?
Right, except for Ms. McGovern.
Okay, now if that is if she is the only one, the only African-American.
Yes, ma'am.
And she is the only one that is subject to the settings changes, that has just as much, it seems to me, force as saying that another African-American person.
Right.
I didn't read in the record that there was another African-American person. The comment about this is why we are going to have African-American folks seemed to me to be forward-looking.
I believe it was forward-looking, but I know that at some point another African-American came into the MTS section. So she comes in 2007. At some point, another one comes in. It's referred to obliquely. I don't know when that happens. So my time is rolling down.
Well, I think the question that Judge Niemeyer posed to you about the connection between the playing with the machines
Right.
and the racist, clearly terrible racist things in the beginning
Right.
is maybe anything you have to tell us about that would be helpful.
Sure. So Bridgestone claims that it had no knowledge of the racial character of this sabotage, this what I would call the connective tissue between the extremely racist beginning and then the forced transfer. When Ms. MacGyver goes in and meets with Mr. Moeller in 2017, he asks her, where did this all start? And what does she refer to? She refers to Mr. Hawley hanging that noose. She identifies him as the source of it and the racial component of it as the source of it. So they were on notice of it. But even if they weren't, even if we just set that to the side, they cannot enter into a see no evil, hear no evil kind of approach to things. And that is really highlighted by the conversation with plant manager Dar. She goes up the ladder. She goes to Ms. Hauser, she goes to Mr. Moeller, she goes to plant manager Dar, and she brings her complaint in. Mr. Dar says, you need to apologize to the boys. She says, who are the boys? And he just repeats himself. You need to apologize to the boys. Well, what do I need to apologize for? At least tell me. You just need to apologize. When he makes comments like that, that are showing such a cognizance of, I don't want to put anything on the record, I don't want to say anything, they are deliberately trying to create a record of, nothing is going on here, not even a denial. But that's just them, and I see them over time. That's just them pleading deliberate ignorance.
All right, you have some rebuttal, Mr. Hayes. Let's hear from Mr. Sarakanian.
Thank you very much, Your Honor. May it please the court and counsel. My name is Nicholas Sarakanian. I'm with Holland and Knight, and I'm pleased to be here, especially in person, on behalf of the Bridgestone appellees. I'd like to start first by answering a question that Your Honor, Judge Richardson asked to my colleague about, and I believe Judge Motz also asked about whether another African-American employee joined the relevant section within the plant, which is the MTS section. If you look at the joint appendix, the record shows on page 185 to 186, which is Ms. MacGyver's deposition testimony. She testifies that another African-American, a gentleman named Brian Exum, came after she did to the MTS department. The record is devoid of any mention of Mr. Exum facing or alleging or claiming anything similar to Ms. MacGyver's claims of tampering or messing with or sabotage, which I agree is a loaded term. So I want to start off with that.
So I'm looking at 185.
Yes, Your Honor.
And I'm looking for Brian. Oh, I see. I think a year later, if I'm not mistaken, that's when Brian Exum came.
Yes, Your Honor.
And Chris Hawley said this is the reason why Black people got to come to the crew. And so it's your representation that he stayed there too?
I do not know that, so I can't represent that, but I believe that's the case. There's nothing in the record to suggest one way or the other.
I thought you represented the company. You just might have talked to your client.
Well, I do, Your Honor, but I don't want to speak about anything that's not in the record strictly there.
My experience is when lawyers don't want to talk about what things are not in the record, those things that are not in the record do not help them. But go ahead.
Well, I assure you that's not my intent. So I do want to speak about the questions that we had regarding the tampering and also the timeline, which I think the timeline is particularly important in this case. Judge Richardson, you make good points about what's in the complaint. If you look at what's in the live complaint at the time the district court was ruling on the summary judgment, there was no mention of Mr. Hawley saying anything of these statements in 2007 or 2009. We were doing fine comment or she's the reason other Black people came to the section. That's not in there. And
does that matter? I mean, I understand atmospherically your point, right? That might cause us to question her later claim in the deposition that attempts to tie her allegations to the terrible conduct that existed before. But I mean, she did say it in the deposition, right? And maybe that's not credible, but we don't get to make that judgment at a summary judgment level. is not in the complaint. It hasn't been alleged before. She makes the allegation for the first time in her deposition, but does that matter?
I think it does for at least two reasons, Judge. First, the brief, I think it's fair to say, centers on that character, Chris Hawley. The brief is centered on his conduct because, as opposing counsel pointed out, there's roughly two categories of conduct that's being discussed in the brief. The first one are the things that are, that Ms. McIver admits were not directed at her, right? The things that either she didn't perceive or see or heard secondhand, that we have that category. And then we have just the two references to something Mr. Hawley said, who, by the way, we pointed out in our brief, and she says in her deposition that she's friends with Mr. Hawley.
She used to be friends with him. He changed. That's what she says.
She says he does. She did say he changed, but she said that she based that off of something someone else had told her, that he wasn't the same as when they had worked together in the other department. But it's never gainsayed in the reply brief. It's something that's not mentioned, but I think that is something to consider. And I think the district court was entitled to consider the timing of the report of what Mr. Hawley, whether friend or otherwise, told her. As counsel pointed out, it was not until 2017 that the statements allegedly made by Mr. Hawley, the statement about the noose, the admission of hanging the noose that was hung in 2006. In 2007, we were doing fine comment, which Ms. McIver says was made soon after she joined that department, the MTS department. And the 2009 statement that Mr. Hawley allegedly said, which was, that Ms. McIver is a reason why other Black people came to this department.
Well, was there any evidence to the contrary?
Excuse me?
There's her deposition testimony, and you're suggesting that maybe it's not credible. I was asking, for example, did you take Mr. Hawley's deposition? Do we know that this is, as it comes to us, it's undisputed?
Well, the point I'm making, Judge, and the answer is, I'm not necessarily saying it's not credible. We shouldn't consider it. What I'm saying is that, as counsel admitted in the briefs and here, management, human resources, Mr. Moeller, Andy Moeller, he was not told by Ms. McIver. She did not report those statements from 2006, 7, and 9 until 2017, which is important, not only because of the large gap of time, the large lapse of time, which in itself is important, but it's also important because it came after she started to complain about her performance review she had received a year prior in 2016. So in 2016, she receives a performance review saying teamwork, troubleshooting needs to improve. She complained about the performance review to management, but it wasn't until 2017, after that year's review, which was based on the 2016 review, that she tells Mr. Moeller, oh, this all started back in 2007 or 2006. It's unclear what the record's not extremely clear, but that's the point I'm making, is that you have the large lapse, and from a causation point, the thing she was complaining about, the remarks in her review had already occurred.
Well, but her source of great complaints was messing around with her machine.
Absolutely.
And she maintained that was before she complained about her review. In fact, that led to the review because the employer says that these aren't valid, or she takes too long or something, and she says that she has to get the machine working. So that all happened before. In her mind, I guess, if we take this to the best light for her right now, she has these racist things happening. Then she has the machine being messed around with, and then she gets a bad performance review. So you say all she's done is complain about the bad performance review, and all she did was bring out these earlier things with respect to it. But she has been complaining in her mind, maybe not, maybe the record doesn't support this, the messing around with the machine is related to the racist remarks.
Well, I agree with.
And we knew she did. You don't dispute that she complained about the machine before the bad performance review.
No, not at all. That's the part. That's the part of the question I absolutely agree with. Is the point I'm making, and I'll leave it I'll leave it right here. But the point I was making was that going to the complaint, the central figure of the brief, Holly, is mentioned in one paragraph about the news, but the statements that were directed at Ms. McIver, the 2007 and 2009 doing fine remark, here's why other Black people could come to the department, not in the complaint. And
Well, it doesn't have to be in the complaint. Because, I mean, in the civil context, we have rules that characterize the various stages of the proceeding, and the complaint is intended to put the defense on notice, and pleading evidence is not required. It seems to me what is important in this case is what was the record before the district court in granting summary judgment. And I don't think we're allowed to go beyond the record or have the record supplemented. The right approach might be to figure out to have this thing remanded for some reason to have a larger record made. But I think at this point, we're faced with a record that was made before the district court on summary judgment, and we have to determine whether there was a dispute about a material fact such that a jury could find. And I think, I mean, we all know that standard, but I'm just trying to de-emphasize the reliance on the complaint and focus more on the record before the district court.
I absolutely agree. And I'm sorry, I was trying to just be thoroughly rounding out the
I understand
point.
what you're, I just didn't want us to get bogged down on the
Absolutely.
complaint, because they could have said a lot less in the complaint, still had a complaint.
Absolutely. And this is not a appeal from a motion to dismiss. So I absolutely agree. But to Judge Motz's question, yes, she did complain about the tampering. We'll just say tampering, you know, and that should include whatever species of that were discussed. She first complained about it, according to the record, according to her deposition, in 2008. And then there was a 2013 complaint that she made via the Bridge line, which is Bridgestone's EEO policy and hotline to report things that are, you know, considered to be violations of Title VII or otherwise. And there's a lot of discussion in the brief about the adequacy of the investigation in 2013, which I do want to talk about, which is important. But the point, just to finish answering Judge Motz's question, is we contest that her complaints regarding the tampering or the machine were based on race, which was her burden to prove at the district court, because it had to be a protected activity. It can't be a complaint about, you know, things that are not related to, you know, protected status. It has to be something related to her race in this situation.
As I read the record, she filed a couple of complaints with the EEOC.
Yes,
We don't have those complaints, of course, in the record.
right.
Maybe you've seen them, but you don't usually file with the EEOC unless you make some sort of complaint that would be covered by the statute with the EEOC.
Right, which is obviously a logical
So
thing to
that
say.
would suggest that she did make the bridge between the tampering and the matters that the EEOC would be interested in, discrimination.
Yeah, I understand the point. And you know, further to our prior conversation, it's not in the record, the actual complaints, the dismissals by the EEOC. I think there's 2 of them in the record there.
So we know
But
she filed 2 claims.
She filed 4 in total.
Yeah,
She actually,
and we
filed-
don't even have what happened with the others. We don't have the dismissal order, right?
I'm not sure. I know that I counted at least 2 of them in the joint appendix, is what I'll say. But the point is that when she is speaking to other people at the plant, you know, she is talking about the tampering with the machine. And so when she moved into this department in 2007, the record's clear that she was the first African-American employee there. We now know that Brian Exum joined within a year or 2. And the point is that when she was talking about the tampering, and these were investigated, and that's why I want to jump ahead to 2013 and talk about that. It was not clear that it was based on her race. And it wasn't until 2017 that she arguably tied. And I say arguably because if you look at the record citations, which I know the court has and will, there's a lot of record citations that don't quite get to where the brief wants it to get. So for instance, complaints about that were made in 2008, for instance, were not about Holly as it was suggested on page 23 of the opening brief. If you look at the joint appendix at page 179, 180, you'll see the context there. And going to the 2013 investigation, there's something that is quite interesting in the record that was not brought up in the opening brief. And that was, for all the complaints of Bridgestone's investigation into the tampering in 2013, she went to an employee, David Byerly, and he was investigating the tampering with the machine in 2013. She essentially faults Bridgestone because Mr. Byerly, according to her, only asked 3 questions and they were all directed to her, she says. But one thing that's incredibly interesting is that she did not provide any corroborative evidence, even though there was, according to her, another employee, Spencer Manning, who could corroborate that something was going on with the machine. She testified in her deposition that she didn't want to involve Spencer Manning and withheld that information, essentially, from the investigator. So when we talk about the adequacy of the investigation and the reasonableness of Bridgestone promptly, investigating the allegations of tampering, that's something that should also be considered. And if you look through her deposition, there's other instances of not wanting to involve people or not coming forward with everything she had. So going back to where we started a little bit, there's these instances of what she says were, racial conduct directed at her, the statements made by whether current or former friend Holly, that were not told to Bridgestone for over a decade. There was withholding, I would say, or not providing helpful corroborative information that would aid the investigation of the tampering in 2013. So it's hard to fault Bridgestone when there's these things being held back. And so it goes to
maintain that Bridgestone didn't know about the earlier clearly racial things that happened, the nooses.
no,
Bridgestone did know about those.
I'm not contesting that they knew about that because, in fact, and as you see from the opening brief and the record citations, Bridgestone did investigate those things. So, for instance, the 2006 noose incidents or these instances of the rubber monkeys and the graffiti, you'll see from her deposition testimony that Bridgestone did investigate it. But the problem is, going to the point I was making, the brief suggests that nothing was done, or this gentleman, Jason Wheeler, who supposedly is the one that took the fall for the noose incident, was not disciplined. But if you look at the actual record, it's based on lack of personal knowledge. She wasn't involved. She wasn't present. It was sometimes based on hearsay from another coworker who was not involved. So the things that—
Did the company offer any evidence that they had investigated, or that does the company claim that the incidents didn't happen?
We're not contesting on appeal that these other incidents happened.
Okay.
What the point is that to go to the hostile work environment claim, to root it back in the claim here, is it sufficiently pervasive and serious, especially when you have all of these lapses of time, right? So for instance, the noose incidents in 2006 in the MTS department, where she was not working, she was in a different department at the time, happened before she got there. Now, obviously, all of these things are terrible, right? They're reprehensible. They're not right. But that was one instance where she was not involved. Then you had the 2 incidents with the—
Can you help me?
Sure.
In 2006, when there's a noose incident, there are no African Americans that are working in MTS, right?
According to Ms. McIver's testimony, that's right. Yeah.
And so, the obvious implication is that the noose is race-based, and that totally makes sense. But I'm not just it just struck me as sort of odd because, it's in a section where there are no African Americans. What do we have? Is there any record that suggests what that was about?
The record doesn't have a lot about that. And I will also say that, just to clarify, I think there's some times in the deposition of Ms. McIver where it's not very clear of whether this was hung on an African American's machine or whether that was in the MTS department or the Times. So a lot of this is trying to put the facts together from the record we have here.
Because you at least Bridgestone seems to suggest that that actually happened in 2000, not 2006. Obviously, we have to take 2006 for this purpose. But your point is we just have to take that as the record. That may turn out not to be true, but there's evidence that could support that happening in 2006.
I think that's right. Yes, I think that's right. But the point is that you have these instances. So if you're looking at the hostile work environment, and obviously, from the court's en banc decision in Boyer Liberato, that can be, you can meet that by showing something that's, extremely severe, even if it's isolated, maybe one or two remarks, or pervasive. And so the problem is that the cases that I've read from the court is when you have, again, back to the two categories, directed at or kind of, not directed at the person. The cases where the severity alone has sufficed, I would say tend to be directed at the person. So for instance, I think it's pronounced Xerxes, EEOC versus Xerxes case. I don't know if that's the right way to pronounce it, but those were directed at the plaintiff or the complainant, Ingram. It was very clear that the religiously based harassment was happening to him and that there were other things in the environment. But in this case, and of course, Boyer Liberato as well, that those comments were made directly to the plaintiff. So here, I understand the approach and the theory of the case from Ms. McIver, but ultimately you have too many gaps, not just in time, but also, what's directed at her or not. And to just zoom out and say, focusing just on the things directed at her, the two statements, which I'd say the record suggests, either they were friends at one time and that stopped, but the point is that she said she didn't report Mr. Hawley because he was her friend and they had gotten along. So the two remarks that were directed at her were not reported to management. Obviously, there is an obligation to report these things. Bridgestone does have these policies. It has the bridge line. She did avail herself of the bridge line and the EEOC, and I see I'm out of time, but
Can I ask you a question before you sit down?
yes.
I thought you were going to focus, and you sort of mentioned it, on the time difference
Yes.
between the time that elapsed. And do you have your best case in which a discrimination case was thrown out because of this kind of distance in the record? Because I'm not sure on summary judgment that's a basis for us to go your way. It surely would be, in front of a trier of fact.
Well, I think I would refer you to the brief where we cite Perkins versus International Paper Company and the other cases where the court has held that a gap of even a few months between, for instance, going to the retaliation claim, between a protected activity and the conduct. So,
But see, on the retaliation claim, there isn't the big gap. I mean, according to her.
well, I would at least point this out. I believe there is a gap because, again, even if you assume that she's right about the timing in 2017 telling Mr. Moeller, well, it all started way back then, that was still in 2017. It wasn't until April 2018 that the transfer was presented.
Yeah, but she says it's because, this may not be true, but your people didn't, apparently their affidavits aren't in here and we don't have any evidence to the contrary. She testifies that it was because she had been complaining about the machine, and she's complaining about the machines because they are played with because of her race. That because of that, she's transferred to this other place where she doesn't want to be. And then she right away says that is a discriminatory action.
I understand, Your Honor.
So there's no lapse there.
Well,
She says that's the basis for her retaliation claim.
Your Honor, I respectfully would say it's not clear what she is saying was a protected activity, when it was done, and which one is close to the one that is the right one to look for retaliation, because there's a lot of different instances of her talking about vaguely, by the way, and the court does look to that as far as specifics on whether that's enough to
Let me
support.
understand what your position on the record is. The most recent racial comment was in 2009.
Yes, to her
And
directly.
so after 2009, up until 2013, when this sort of started, there's no complaint of race or no racial incident in the record that could support the causation for the tampering in 2013.
Well, I think that's correct. And the reason I say I think is that she did file an EEOC claim in 2014, but I believe your sequence is correct. That first off, the last statement that was directed to her, we're on the same page, was in 2009. She complained in 2013 about tampering. We dispute that it was linked to any racial comments made to her, which had not been, by the way, the two comments directed to her, even in 2013, were not reported to Bridgestone. It wasn't until 2017. So, but I think that helps clarify the timeline, but I'm happy to answer any other questions the panel may have.
Sarah Connion.
Thank you very much.
Yeah, Mr. Hayes, you have some rebuttal.
Yes, Your Honor. So I think this court has really circled in on a central question, which is, what do we do with this facially neutral sabotage material between, the last.
I would have a lot better time listening to you if you didn't call it sabotage.
Sorry.
And it is a tampering.
Tampering.
But sabotage suggests that the machine is being destroyed and undermined and damaged, and the motive is to disable the machine.
I certainly don't mean
It
that.
sounds to me like she has legitimate tampering claims. Somebody is annoying her,
Right.
and causing her an inability to perform well her job, which was included setting up the machine.
Right.
Yeah. All right.
And that tampering, I'll use that word, to the extent it is grounded in has a racial character to it, that strengthens the severity analysis. It strengthens the causal link. Can
you return back to your answer? Judge Mott's asked you a question, and I don't know whether if you finished, great, but it wasn't clear to me. She asked, what evidence do we have that connects the 2006-07 clearly racist activity to the 2015 and later timeframe, which is the predominant tampering allegations? And you pointed to a 2017 meeting and a meeting with Dar. Is there anything else that you think supports the connection between those two?
So I guess it depends, Your Honor, on when we say connection, are we talking about what was actually factually true, or what Miss MacGyver had kind of as her own investigator presented and proven? And I think those are different things. Bridgestone keeps basically presenting it as if Miss MacGyver had to be, I don't know if y'all remember that case, that TV show Matlock. I used to love Matlock, but they're doing their own investigation and they're figuring things out. Ms. MacGyver is not under the duty of connecting all those dots. She doesn't know a lot of times who has tampered with her machine, but she says, this thing is happening. This thing is happening. And everybody knows, she and everybody knows that.
Right. But assume that, maybe it's a hypothetical, but assume that her machine is absolutely being tampered with. Right. And that's 100% certain.
Right. The set of data backs that up.
And it is also and let's imagine, just for my hypothetical to clean it up a little bit, that we have evidence of that from 2015 forward. Right. We also have undisputable evidence that in 2006, 7, and 8, there are terrible racist things that happen.
Right.
At the plant, right? What I'm trying to get at is, what is the evidence that those terrible racist things are relevant or helpful to proving that the tampering was racial in nature, as opposed to like a personal problem or just a general dispute or a competition among workers for a promotion or all the other possible things that you could tamper for lots of reasons.
Sure.
Why are those things relevant to the tampering?
Right. So first, I would say at summary judgment, this court should not be weighing the facts and making the distinction about whether hanging the noose on a machine and changing the settings on a machine are such different things that we can't make that connection. They're both messing with the machine of an African American. And I did find the citation where the hanging of the noose.
I don't quite understand that argument. You're suggesting that don't you on summary judgment carry the burden of proving your claim sufficient that it can go to a jury? In other words, if the evidence is lacking, then the district court would have been justified to throw it out.
What we're saying is at summary judgment, the question is, could a reasonable jury make this connection?
Well, that's right. But you have to have evidence. The question to you, and I'm still listening, but the question to you is, what is the evidence that links the historical offensive conduct to the tampering that occurred years later?
Right. And two things to that. One, I think a reasonable jury could conclude if you hang a noose.
For the evidence, if
you hang a noose,
we know the standard, but I want to know what the evidence is that the record contains that links the two.
Just that if you hang a noose and you hang monkeys on African American workers' machines, as they do, and that found that reference that it was an African American machine, that's JA 215. A reasonable jury can then say when the only African Americans sections.
I thought you said that she was the first African American there.
Right, but that's in a different section. So the noose and the monkeys are not in her section.
Is there any evidence that that's within a decade of the 2015? I mean,
2006
could have happened in 1960, based on the record, could have happened in 1967.
No, she says 2006. I mean, in 2006, the hanging of the noose, and we know
and that's in 2015. No, I understand the noose. I'm talking about the monkeys.
The monkeys we know happened after the noose, but we don't know exactly when.
And I can find that at 215. That's where it says it happens after the noose.
No, 215 is about the noose, the original noose. The monkeys. Sorry. The monkeys.
It's okay. But we don't know. All we know is that it's after, her allegation is that it's after 2006, but we don't know when after 2006.
Right, that's right.
Caricatures were after 2012 or 2013. JA 243 to 44, right?
That sounds right. My only closing point is that, and I see I'm over time, is to really dig into the see no evil, hear no evil. They are going out of their way to avoid evidence. And, if there is anything less you can do in an investigation than to ask the alleged perpetrator, did you do it? Then there's not much less than that, because they're just going to say no. And that's all they do. What's their investigation? That would be the question I would pose to them if I could ask them one more question is, why didn't you do anything? Why didn't you just go down and look at the machine?
You had the opportunity to depose them, didn't you?
We did, but it's not our burden to
burden to carry the whole burden of proof.
It is,
and to demonstrate in the record why you're entitled to summary to go forward with your claim.
That's right. Well, Ms. McIver presented evidence of the tampering, and there's data to back that up. She doesn't have to disprove their best argument to the counter.
No, but going back to Judge Niemeyer's question that led off the rebuttal, it was that what evidence do you have in the record that links the terrible racist things in the beginning and the tampering with the machines, and in suggestion that the tampering is also racial based? Right. And it seems to me the best evidence you have is your client's testimony. She thought that.
Right.
Now, she may be disproved, but that's what's in the record.
Right. And I think that the thing she experienced at that time, which was sabotage when she saw the person running, tampering of some kind, when she saw the person running from a machine, that's repeated. If someone uses the N-word and then the next day throws a wet paper towel at your back of your head, like they do in the Xerxes case, that wet paper towel has racial charge to it. If another wet paper towel comes a week later, a month later, a year later, same racial charge. It doesn't have to be accompanied by monkeys and nooses every time. I see my time's up.
All right. Thank you, Mr. Hayes. Do you want to go down?
Supposed to. Because
Okay.
you're the state.
Yeah. Okay. I was trying to consult. We have a tradition, as you guys probably know, to come down and greet counsel. It's a grand tradition we've carried on since the 1930s. And we are not abandoning that tradition, but we have suspended it during the COVID era. And so I think we'll continue in the wisdom of that. The next time you come, I'm quite sure we'll come down and shake your hands. But in any event, we thank you for your arguments. And this little comment by me on behalf of the court should suffice until the next time. Thank you very much.
Thank you very much, Your Honor. Thank you.
We'll proceed on to the next case.
They're coming in from the hall.
Oh, so we delay the entry of lawyers before I got it.
Yes.
All right. Sorry. I was looking in the back for one of our candidates there to be a lawyer.
What?
And I'm calling the next case of education. Just to let you know, we're pleased to have you present in the court. This is our first in-person argument this week, first in-person argument for almost 2 years. And it's back and have the institution functioning somewhat in the form that it has traditionally functioned. Mr. Byrd, whenever you're ready, we'll hear from you. Thank you, Your Honor.
Good morning, and may it please the court. My name is Quentin Byrd, and I represent the appellant, Wendell Tabb, in this matter. Although I'll say at the onset that this appeal stems from both a grant of defendant's motion to dismiss, as well as a summary judgment order, my argument will primarily focus on the order grant and summary judgment. The district court, in our opinion, erred in three distinct manners. First, the district court erred in determining that Mr. Tabb was not subject to an adverse employment action. Second, the district court erred in determining that plaintiff lacked adequate comparators. And third, the district court erred in concluding that plaintiff was not treated less favorably than his comparators. In order to show, as this court has laid out in the case of Garner v. County of Chesterfield, Mr. Tabb was required to show that he was a member of a protected class, he had satisfactory job performance, and he was required to identify an adverse employment action in that similarly situated, that'd be the comparator language, similarly situated individuals outside the protected class were treated more favorably than he was. As to the issue of adverse employment action, first of all, although most of the appeal and the trial court's discussion stems around the issue of the technical assistance that Mr. Tabb was not provided, but I will note that it was raised in the complaint. There was a discussion about the additional hours that Mr. Tabb was required to work, which this court has slightly addressed in the case of Boone v. Golden in 1999, discussing whether or not an additional burden or disproportionate assignment of workloads can constitute an adverse action. And I'll say for the record, we still contend that it does. But the primary issue in this case is the failure for the county to hire Mr. Tabb or provide technical assistance, which one could come in the form of an actual hire of a teacher. But there are also other methods by which the DPS could have provided Mr. Tabb the necessary support. That being a contractor, classified position that's converted, or a contractor like Mr. Will, I forget his name now, was hired in many years by DPS and that to provide that very support. So the rule is established in Hishon and Supreme Court is that a benefit that's part and parcel of an employment relationship may not be doled out in discriminatory fashion, even if the employer would be free under the employment contract simply not to provide the benefit at all. And so I think key in this case is defining part and parcel, which I think this court, even in its discussion in Garner, it's not well fleshed out in case law. And so this is my submission to the court. In determining what's part and parcel in this context, I would submit to the court that a benefit may be considered part and parcel of employment if it's central to the employment relationship, so that in its absence materially changes the terms of employment and substantially impairs the employee's ability to perform his job. So in this case, I submit that the failure to hire a technical theater director or provide the technical support does affect a privilege of employment and is part and parcel as defined by the Supreme Court's case in Hishon. For example, it's undisputed in the record that every director in Durham Public Schools was required to put on production. This is not the compensation that Mr. Tabb received for class time. This is work done after class hours. It was expected, and it was actually part of Mr. Tabb's evaluation. He was required to put on these productions. And the failure, the work performed by the theater tech directly impacted Mr. Tabb's performance, and it was a prerequisite to a successful production. And I would contend it was inextricably tied to the director, Mr. Tabb's ability to perform his job duties. So that in its absence, Mr. Tabb was compelled to perform the additional work. And I would akin it to, Your Honors, the example I would submit to the court is that if we were to consider the hiring of law clerks for judges, while it's true that it's the judge that authors the opinion and they can do the work themselves, however, it's not reasonable, especially in the current climate, to have a federal judge do the work on their own and not have the support of a law clerk. And in that way, I would say that having a law clerk would be kind of part and parcel to a judge's job.
Can I ask you a question about this? And I confess, I'm not a theater guy. But if I'm the theater director and I agree to put on performances, But the amount of work that I put into those performances seems to me to be my choice, right? So imagine instead something I know a little bit more about is imagine I'm a football coach, right? And my job is to coach the team. And so that has certain requirements. But, I spend all day every Sunday reviewing film so that I can develop a better game plan, right? But that's not a required part of my job, right? It makes me better at my job. And I choose to do that because I want to give back to the kids and all great, laudable goals. But then I go and I say, well, I want you to relieve me of this extra work that I'm taking on, right? So yes, he has to put on performances, but does he have to have sets for each of them? Lots of plays are put on with no sets, right? Does he have to do lighting in a professional manner? Well, I'm sure it's better in the same way that, a football coach watching film would be better. But is that really like the part of his job that he's required to do? It seems like to me, to his great credit, he's going above and beyond what is required of him, but then also complaining that I'm having to go above and beyond when that's his choice. Help me understand why that's not the way to think about your client situation.
Thank you, Judge Richardson. I would say that the evidence does not support the idea that this was Mr. Tabb going above and beyond. As I stated, that all the production, all the theater productions in the county all had lighting, sound, and things of that nature. Again, kind of going back to the federal judge comparison, it wasn't until I think 1936 that federal judges had clerks. So yes, the job could be done, and Mr. Tabb, in fact, did do the job without the assistance, but that work was necessary to him performing his job duty. And to say that Mr. Tabb, as a Black male, was not required to, his productions should not have sound, his production should not have lighting, and that to do what has become normative, especially in today's society. If this was 100 years ago, the answer may be different. But in today's society, all the plays have sound, they have lighting, they have sets, they have things of that nature. And so I would say it's different.
Would you, based on this, I just read this record, and maybe this is like not totally relevant. So I'll stop after this question because I'm not sure it's actually relevant to the legal issue. But I read this as Mr. Tabb was a teacher who went above and beyond. He was not a guy who was doing only what was required of him, right? And that's why he was a successful teacher, and that's why it at least appears from the record, he was doing quite well. But that's because he was doing more than he was required to. Should I not read the record that way? I should read the record. It seems like you're suggesting that he was doing what was required of him and nothing more.
No, I would agree with you that he went above and beyond, but that's not the basis for the lawsuit. Let's say, for example, go back to your football example, and this might not be a direct comparison, but the coach is required to show up for practice. Mm-hmm. The film in that instance in your example, that might be extra, but looking at additional film, but showing it for practices. And so yes, Mr. Tabb did go above and beyond, but those things that he did above and beyond are not the basis of the lawsuit, because again, it was not only Mr. Tabb, it was Ms. Keystrong. Every director in the county had to produce this level of work, and it wasn't a matter of quality. I'm saying our condition is that the base level work that Mr. Tabb performed was necessary and part and parcel, and that was not the minimum standard, was not given to him in equal manner. Now, I agree with the court's contention that anything above and beyond that was outside the norms would not be compensable. That would not be subject to Title VII.
Why is it, in the end, I said I was going to stop, and then I don't follow my own advice, but why is the norm the right question as opposed to what was required of his job, right? So he's required to put on performances, but the quality of those was not directed. So it may well be that theater directors, as a general matter, are devoted to their job. And so if everybody is going above and beyond, which is probably true in most high school settings, theater teachers and football coaches are probably both going above and beyond. Why do we look at the norm? Why does the mean matter as opposed to what is required for that position?
Well, my first part of the answer would be that we're going to a benefit, not just what Mr. Tabb did and the work he performed. The benefit that was provided to other non-white comparators in the school system was that they had a tech. And so if that's a benefit that's provided, Hishon demands that it must be doled out in a non-discriminatory fashion. And so it's the benefit additionally provided by DPS that subjects this to Title VII scrutiny. And it's a different job. It's different. So my analogy would be, if I worked at a fast food restaurant and I was a cook, and every time I worked, I had to cook and to run the register. Those are two different job functions. They work together to make the whole thing work, but they're two different functions. In this case, Mr. Tabb was required to both cook and run the register. So it's not above and beyond in the sense, because this was a different job duty, usually done by different people when the director is not a minority.
Let me ask you on a little bit different subject. If I understand correctly, the school board generally allocates a number of teachers to the schools based on the student population. It's not a perfect ratio, but they have a ratio, and they deviate from that ratio sometimes. And in connection with the Hillside School, actually, it was allocated more teachers per student than other schools in its district. It might have been had the highest rate. As I understand it, then the principal of the school then takes that number of teachers and assigns them to particular tasks within the school that the school is providing to the public. And in the case of the Hillside School, they were fortunate to have Mr. Tabb, of course, do what he was doing, but they also had two additional programs that required additional teacher support. One was the program for the underachieving students, and they needed to staff that. And then they had a program on the International Baccalaureate program, which they had to staff. The principal was very sympathetic to Mr. Tabb and actually did want to help him out and get him an assistant, and made that request several times, didn't he?
Correct.
Yeah. So really what we're talking about is challenging the school board's decision to allocate students to a particular school. And you're requesting the school board provide yet more teachers to the Hillside School, even though they have already providing more than other schools on the ratio they look at, the student ratio. Doesn't it come down to that?
I'm glad you raised that, Judge Nehemiah. I disagree with the couching of the framing of the issue by the district court, because the comparator is on an individual.
No, I'm not looking at the comparator. I want to understand structurally how the teachers, in other words, basically your claim is that somebody should have provided Mr. Tabb with an assistant.
There's two ways.
And my question focuses on where are we going to get this assistant? And your argument is the school board should have allocated some more teachers. They don't allocate particular jobs. They allocate a number of teachers, and the principal then does the assigning of the teachers to particular courses and tasks.
So there's two ways that could have been done. One, your Honor is correct in that the providing of an additional allotment is one way. And then the other way is that the principal's request to use the current allotments were obviated by the school board, directing them on how to use their allotments. And the reason I believe that it's permissible to discuss the necessity for the school board to allow the additional funds, like the school improvement grant that was federal funds that could have been used, is that we're talking about means versus anything else. So DPS did have the ability, but disagreed with the means. It wasn't a matter of did they have enough funds. DPS said, we have enough funds, but we don't choose to go and use it this way. So there was issues on the classified position, a contractor like Mr. Holly, and also evidence that the school improvement grant was denied, or Mr. Lasser's request that the current photography position that was going, the photography teacher that was retiring, that be used to support this position, and it was a school board that made that decision. So I believe, and I see that my time is up, that the additional allotment would be permissible because that's just saying the means by which Mr. Tabb would be made whole, but not it precludes his recourse because the specific means by which it would be provided to him.
All right, thank you. You have some rebuttal. We'll hear from you again. Mr. Scheib.
May it please the court, Colin Scheib from the law firm of Tharrington Smith on behalf of the Durham Public Schools Board of Education. The board acknowledges and appreciates Mr. Tabb's decades of service to his students, to the Hillside community, and to the school system at large. The board also, however, maintains that Mr. Tabb has been treated equally, in some cases better, than his similarly situated colleagues. Mr. Tabb's main claim is that for years, Hillside High School did not hire an additional technical theater teacher, and that this was due to his race. Mr. Tabb's claim is unsupported by the facts and the law. Jumping straight to the issue of the part and parcel analysis under Hisham. The first point I'd like to make is that in appellant's opening brief, this issue was not raised. That was a clear dispositive holding of the district court below with respect to the adverse action, and that was not at all addressed in the appellant's opening brief. Under well-established law of this court, that issue is therefore waived.
What is the issue that's waived?
Right.
The issue of part and parcel analysis, whether or not the assignment of a technical theater teacher to individual teachers such as Mr. Tabb is an adverse employment action. That was not at all addressed in appellant's opening brief.
Well, he characterizes it a little differently. He basically said he's required to do more work by reason of his position than other people in a similar circumstance.
Yes, Your Honor, and I think that goes to Judge Richardson's point. Mr. Tabb, like many teachers in the school system, they go above and beyond for their students. That's what teachers do, particularly theater teachers and football coaches. I think the analogy to the football coaches is a good one. And thinking about that comparison, my initial thought is that Mr. Tabb has been asking for, an assistant coach to help him coach the team. That's not even really the correct analogy because a technical theater teacher does not assist Mr. Tabb teach. It's a different teacher assigned to the school to teach a different class of students. It would really be like a football coach looking at his stadium on Friday nights and saying that our facility is not up to par. We don't have proper lights for our game, that the stands are not clean, that the lines of the field have not been properly painted. And because I want to go above and beyond for my students and for the school, I want to make the stadium and this field look better so they can draw bigger crowds and have a better game. Mr. Tabb has chosen to do the analogous version of that with respect to his theatrical productions. His extra effort that he has put on to produce high quality plays, as the district court noted, is laudable, but it cannot serve as the basis for a discrimination lawsuit.
Can I ask you about the smallest claim, if you will, here, the technical supplement claim, which the district court dismissed as, I think it dismissed it on a motion to dismiss. Is that not right?
Yes, Your Honor.
And as I read it, he alleges that as a result of his failure to provide him with a technical director, he was required to do the job of 2 teachers because extra work was necessary to stage high quality theater productions. Now, I think the rejoinder that we've suggested in our questions is, well, you don't have to do, all you have to do is do the job. You don't have to produce high quality. But I think there's enough in this record that suggests there's a lot of competition between these high schools, and the school got a lot of awards. And maybe that was part of it. We're now just on a motion to dismiss, you understand, that there is enough evidence or allegations in the record that was a part of his job and a requirement, if you will. He says that he was required to do technical work to fulfill his own duties. He failed, and it was necessary to stage high quality theater productions. Do you dispute that he alleges that?
I do not dispute that he alleged that, Your Honor.
And that claim goes on the motion to dismiss.
Yes, Your Honor. In part, the district court's opinion was also based on the failure of the plaintiff to allege that any theater director in the district could ever receive 2 supplements.
Well, the problem was that other theater directors had the assistant.
But only
So that if that's the case, and we reject the claim for the reasons suggested by Judge Niemeyer that he gets an assistant, then a lesser included equivalent would be extra money.
I think that argument is undercut by the fact that at the time that Mr. Tabb filed his claim, only 2 of the 6 high schools in the district with active theater programs had technical theater directors.
But was one of them the Durham School of the Arts,
Yes, Your Honor.
which he says is a comparator? Now, the district court doesn't get to whether it's a comparator until it goes to summary judgment. But at summary judgment, it finds it's not a comparator with respect to the remaining claims. But we could take that as its reasoning if it could reach the question with respect to this very small claim. And what he said was that he was not swayed by the plaintiff's contrary allegations when he to the website that the Durham School for the Arts had. How can that be a valid comparison?
So, Your Honor, that was actually the motion to dismiss stage when the district court dismissed DSA as a comparator, notwithstanding that.
All right, better yet. But how can that be a valid comparator?
We'd argue DSA is not a valid comparator for the obvious alternative explanation.
How can that be an explanation? You look at the website and you say what you allege about yourselves. You know, I allege on my website that I am the most fantastic federal judge in the world, right? And then we look at some other.
It's true.
Yeah, right. We look at some other federal judge, like Judge Posner. He doesn't allege that on his website. So I'm the most, that just is crazy to say that's a basis.
Well, Your Honor, I know that appellant has taken issue with the citation to the website, but even putting that aside, plaintiff's amended complaint itself alleged that DSA is a magnet school for the arts. So that citation.
Yeah, but that doesn't mean that it has a program that is superior to this one. It doesn't.
I don't think that it necessarily needs to be a program that's superior. I think it provides an obvious alternative explanation for why there's additional art staffing at DSA.
It was used as a comparator by the district court. And the district court said that the reason it wasn't a fair comparator, that this comparator, he said it was a comparator. District court said that's no good because the Durham School of the Arts says on its website all these great things about itself.
Right. And
that can't be a correct rationale.
And I would submit that even setting aside the citation to the website, the amended complaint itself alleges that Durham School of the Arts is a magnet school for the arts. And also, even assuming that there was error at the motion to dismiss stage with respect to DSA, plaintiff was nonetheless allowed full discovery with respect to DSA as a comparator. There were documents submitted, personnel files of DSA teachers were submitted to plaintiff. Interrogatories were answered about DSA staffing and the history of staffing at DSA. Deposition testimony went to the history of DSA and its status as a magnet school. There's a voluminous record with respect to DSA and its magnet program.
So was there, you tell me that the district court's determination on this small issue, I'm not just talking about the monies, I'm not talking about the extra teacher, that there was another determination by the district court on the basis of that evidence?
I believe I'm saying
about a comparator
even
for the money claim?
Even if the district court had erred in dismissing the technical supplement claim at the motion to dismiss stage or dismissing DSA as a comparator at the motion to dismiss stage, that error would be harmless error because there was full discovery on those issues and all those facts before the district court at the summary judgment stage.
Maybe I'm not following. I want to make sure I understand from your perspective. With respect to the second supplement, so like getting 2 supplements, like the Durham School of the Arts, nobody got 2 supplements there.
Correct.
And so why would the Durham School of the Arts be a comparator on this narrow question of whether he can get a second supplement or not?
I don't think there is any valid comparator for
How many
the technical
additional
supplement claim.
helpers did the person have? In other words, it had people rather than additional supplements, right? I'm just reading the record.
Each teacher at Durham School of the Arts is assigned to teach individual classes of students. It's not like teacher assistants in a class with another teacher helping them to do their job. So a technical theater teacher at Durham School of the Arts is not hired to help a theater teacher. They're hired to instruct students.
Okay, but there are additional technical theater teachers,
Yes, Your Honor.
more than one.
But that issue was reserved for summary judgment, wasn't it?
It was considered by the court at the summary judgment stage.
But I'm not directing at that. My questions aren't about that, but that is certainly, I would think, better than a little extra money. So when you're asked, was there an additional supplement? No, but you have to say, no, there wasn't, but there were other bodies available to help him at the Durham School for the Arts.
Durham School of the Arts has a larger arts program because it's a art
Okay.
and arts.
No, I want to go back to the point because I'm curious about this point because why are those like a comparable discussion, right? So if one school says that, you know, we're going to hire a bunch of teachers in this particular area and the other school does not, well, why is that a comparator to getting two supplements, right? Maybe it's wrong at the motion to dismiss, but the point is, at least at summary judgment, you know, the Durham school systems is nobody gets two supplements, right? That's just the way we do it. Like you don't get two supplements. And so there's nobody at Durham School of the Arts is getting two supplements. I mean, he's got to point to someone who's similarly situated, who's getting what he's not, right? And there is nobody who is similarly situated or not that's getting a second supplement in the Durham system.
That's correct.
Theater or not, right? Like that's coaches, band directors, anybody.
And that's correct, Your Honor. At the time that he filed his complaint, there were 4 other theater directors in the district that were in a similar situation as him, that is not having any technical theater staff at their school.
No, we're not talking about staff, we're talking about supplement. I think the dialogue here is focusing on the narrow issue of dismissing the supplement aspect.
Yes, Your Honor. It's my understanding that the questions are if no teacher gets a second supplement, then is the claim then.
Well,
that
then
they have
that should be
additional help.
dismissed, and the alternative is to get an assistant, and that was reserved for summary judgment with a full record.
Yes, Your Honor, and that's when the court ruled that
I
receiving
understand, but I'm just focusing on what the motion to dismiss, whether that was error. And it seems to me on the narrow basis, it's hard to argue that it was error to get rid of that aspect of the case.
I would agree, Your Honor, and the district court listed multiple reasons for dismissal. One goes to Judge Richardson's point about Mr. Tabb's efforts to produce high-quality productions not being a requirement of him. So therefore, it was not an adverse action for him to do this additional work. And then 2, that he had not alleged that any technical theater teacher or that any theater teacher had ever received 2 supplements. I'd also like to point out to the court that the employee in the district who is most similarly situated to Mr. Tabb is actually Olivia Belido. She's the theater teacher at Jordan High School. She's been the sole theater teacher there since 2011. Like Mr. Tabb, she's never had anyone else in her theater department. Ms. Belido is a white female. Like Hillside's program, Jordan's program is also award-winning. It also sends students off to elite programs. Ms. Belido has stated in her affidavit that she often works 12 or 14 hours a day, nights and weekends, doing all of the work required to put on high quality productions, and that she does this for the benefit of her students. She actually went out and became educated in technical theater work on her own accord for the benefit of her program. Over the years, she's repeatedly asked for additional staff in the department to be hired, and she's been by senior administrators in the district and her principal. Whenever she has asked senior administrators in the district why an additional staff person could not be hired at the school, she was told that that was a school-based decision. That's the same rationale that was given to Mr. Tabb whenever he would ask the higher ups in the school system. Whenever she approached her principal about hiring an additional technical theater teacher, she was told that the school could not afford to use one of its allotments for that purpose because it needed to focus on core academic areas and student achievement. Unlike Mr. Tabb, Ms. Belido has never been paid for extra duty work for district-wide events that have taken place in her theater, and her principal has also never agreed to post a position for technical theater at her school. So her principal has been, less supportive than Mr. Tabb's principals have been.
I don't know exactly where this goes. I've never heard the defendant arguing a comparator that is worse off, and that establishes the defense. But you go.
I believe it undercuts Mr. Tabb's claims that there is this person in this very similar situation, and they have been given the exact same justifications that he has.
Worse. The principal is less supportive. That's what you just told us.
Yes, Your Honor. And the justifications given to her are the same ones given to Mr. Tabb. He's argued those justifications are pretextual. And the fact that those same reasons have been given to Ms. Bellido undercuts his argument that they were a pretext for race.
Can I go back to the point I asked your colleague? It seems like what we've got is sort of a three-part issue, and this is the sort of back to my football coach example, right? So he's definitely required to put on plays. We agree with that. And he alleges that those plays have got to be high quality. That's Judge Motz's point that, maybe that's a requirement because there's a competition of sorts and he gets awards. But the piece of that I'm curious about is the middle piece, that to put on high quality plays, you must have like elaborate sets and lighting and the like, which are very time consuming. I mean, we think of some plays, like Lion King have elaborate costumes and sets, and they're really great. Plays have no, set to speak of. It's sort of one or two people on stage, right? And so why is it that we think, or what is in the record that suggests that to produce high quality play, you must have elaborate sets that are time consuming, as an example?
Well, Your Honor, I think the current arts education director of the district, Jeremy Tucker, who submitted his evidence according to the North Carolina essential standards, doing that, then they're doing their job and they're doing a good job at doing their jobs. There's no requirement they put on elaborate plays with elaborate sets to his shows, and he's gotten great recognition for doing that. So that is not a requirement for theater directors to put on such elaborate shows. And I think that the argument that this is required and that everybody does this is belied by Mr. Tabb's own arguments in this case. From the outset, he has argued that the only schools to which he can be compared are Jordan, DSA, and Riverside, because those are the programs with the quote unquote best productions. There are other schools within the school system, Northern and Southern School of Sustainability and Energy, that have also had theater programs during this time period. And he says, you can't even compare me to them because their productions are not as elaborate as mine. So if doing these elaborate productions is a requirement, then why have Northern and Southern, why are they not in that competition as well? And that goes to show that being this ambitious and doing this kind of work, again, while laudable, is a choice that Mr. Tabb has made for the benefit of his students in the school community.
Is that it?
Briefly, Your Honor, the other claim that I believe we have not addressed is the extra duty pay claim. The record simply doesn't.
That's what I was, that all of my questions were directed. Oh no, these are setting up the gym. Is that what you're talking about?
Yes, Your Honor.
Okay.
It's the difference between a technical supplement claim and the extra duty pay claim. Right. The extra duty pay claim was for his allegation that he was forced to work in the theater, for particular events. Extensive discovery was conducted on that and was just simply not supported by the record. The district court in the motion to dismiss order said that plaintiff was entitled to discovery on that issue. That happened, and there was just simply no evidence that any other theater teacher received pay for that kind of work. The only employee who ever received pay for that kind of work was Will Holly, who's a classified non-exempt teacher assistant at Riverside, who received one contract, which is the same amount that Mr. Tabb received. So even if Mr. Holly were a valid comparator for Mr. Tabb, which he's not because he's a non-exempt employee, he was treated exactly the same based on the facts that are undisputed in the record. Thank you.
All right, thank you, Mr. Shive. Mr. Byrd?
I think Judge Motz was completely correct in understanding some of the key issues in this case. One of the biggest mistakes by the district court, and it was alluded to by Mr. Shive here today, is that the court erroneously did two things when it came to the role of comparator. One, it determined that you can only compare individuals within the statute of limitations, which is not consistent with Fourth Circuit precedent, and it conflates the issue of pretext and comparator. If you have evidence that you have a non-discriminatory reason, that may go to the issue of whether there was a pretext or not, but it does not go to the issue of whether somebody is a valid comparator. This court has been clear that when it comes to, so first of all, what is a valid comparator? There's an issue of, again, discussing schools versus individuals. A comparator is a person by person, which means Key Strong, Mr. Clive at Jordan, not the schools. This court has said in Spencer v. Virginia State that while there's no bright line rule as to what makes two jobs similar under Title VII, courts consider whether their employees held the same job description, were subject to the same standards, and were subordinate in the same supervisor. And in fact, had comparable experiences, education, other qualifications. And in fact, the district court got it right for a brief moment in its order on the partial motion to dismiss. The court said, and this is the page 80 of the joint appendix, first, plaintiff must allege the existence of a non-minority comparator, white teachers of the district schools with the same level of responsibility as plaintiff, in parentheticals, i.e. theater directors. That means that every theater director is a comparator.
Why don't you address the theater director at Jordan School in reading the record, it seemed like she was a pretty fair comparator. It looks like they were doing the same job on the same course with the same frustration about not having an assistant. And she went beyond the course of duty and got performance accolades, but she didn't get paid more and she didn't get an assistant.
So to that, the first thing I will say is that Title VII doesn't require that every in this case, non-minority individual be treated poorly as well. The comparator analysis that
poorly, she basically did her job like Mr. Tabb did his job. He's basically complaining that he was denied an assistant. And the question is, in the comparable circumstances, others were denied an assistant. The one school that did have assistants, the School for the Arts, is an art school where their whole program is designed that way, and its structure is not fairly compared to a school that has the general core curriculum.
I'll disagree with you on 2 points, Judge Nehemiah. First, the record demonstrates I think it's in Ms. Olivia Bolito's affidavit, which is page 1634 of the joint appendix, that there was a theater tech hired during her tenure during the 2010-2011 year. And what the district court does is refuses to look at that because the district court has this notion that you can only look at comparators within the scope of the statute of limitations. So we don't look at Mr. Klein and all the support that he had. We don't even look at Ms. Bolito and the support that she had because
what's wrong with that analysis by the court? It seems to me that if you're making a claim that your client's been discriminated against, we have to look at the nature of the claim, and the claim can only be made in the current time 10 years ago if he was discriminated against because one person had an assistant and he didn't have an assistant. That might go to intent or whatever, but it's not to do the comparator analysis. We got to look at your current claim against comparators, right?
That's incorrect, Your Honor. In this 2003 case, Bryant v. Atkins, this court held, we would never hold, for example, that an employer who categorically refused to hire Black applicants would be insulated from judicial review because white applicants that had happened to apply for a position during the time frame had not happened to apply for the position during the time frame. That would make an unworkable system to say, for example, in Heshan, that only partners that were up for partnership during that time frame, the 180 days, those are only individuals that you can look at for comparison. There's no support for it. The district court doesn't cite any case law for that and actually goes contrary. And in fact, another Fourth Circuit case is an equal pay case 1994 Brinkley 36 F 3rd 336, this court said, in the context of equal pay, the statute of limitations does not dictate which coworkers a plaintiff may submit as comparators. The relevant question, as the district court pointed out, is whether during the statutory period, the plaintiff was being paid less on the amount of her sex. So the case is that the comparator.
When it said statutory period.
During the statute of limitations, so during the 4-year period, the question is, did Mr. Tabb not receive the benefit the other individuals had? The fact that they already had it previously for years and years does not mean they're not a valid comparator. They are a valid comparator because they did have the benefit and Mr. Tabb did not.
So before you sit down, can I ask you this question? You have picked your comparator. Are you allowed, if there is another comparator in which your colleague on the other side has suggested that perhaps it's even closer, that would that you do not benefit from comparison to, where does that leave us?
Your Honor, I would submit that as you state, it is for the plaintiff to pick the comparator.
No, I didn't state that. I said, are you allowed to?
Yes, the plaintiff in the.
Why? I mean, it seems to me there are, what, 5 comparators. There are 5 schools that are at issue here. Why are you allowed to pick one and ignore 2, which might even seem to be closer? Maybe the population of the school is closer.
Well, in that sense, the issue is not whether every white theater director was treated differently. That's not the standard. And so the fact that the county may, which again, the record does not support that Ms. Boletto was not provided support because she was provided support, and the record demonstrates that. The plaintiff is not required to prove that every single non-minority employee was treated differently. And that's the issue for the jury to consider.
Your answer is you can pick your comparator.
That it doesn't have to be each one. You can pick some, but not all. The law does not require that every non-minority comparator be treated differently.
One, right? One comparator. It's not like some are, but not all. You don't say the other schools were treated differently. It's only the Durham School for the Arts that is alleged to be the comparator, right?
No, Riverside, Ms. Key Strong, Durham School of the Arts, and the other schools that did not have the assistant, Southern and Northern, also had Black directors. So I think that goes to our point to show discriminatory intent, not to show that there's not an issue of part and parcel. It means that every Black director outside of Ms. Monique Taylor, who inherited that position from Key Strong because she was there before, that every Black theater director in Durham didn't have the technical assistant. And that goes to show discrimination, not to go the opposite way.
All right, thank you. We'll take a short recess and then proceed to the next case.
This honorable court will take a brief recess. Appeals for the Fourth Circuit.
All right, be seated, please. Next case we're on today is Jessup versus Barnes Group Incorporated. And Mr. Arnold, we'll hear from you when you're ready.
Thank you, Judge. May it please the court. My name is Andy Arnold, and I represent Jeff Jessup, who's the appellant in this action and the plaintiff in the action below. This is an appeal from a district court's grant of summary judgment on 3 claims under the ADA that Mr. Jessup had brought against the Barnes Group. He had a claim for wrongful discharge, a claim for failure to reasonably accommodate, and a claim that we styled a hostile work environment. The district court, relying on Halperin versus Abacus Tech, held that Jeff Jessup was not a qualified individual with a disability. And in doing so, the district court ignored evidence in the record, which clearly demonstrated that Jeff Jessup was in fact a qualified individual with a disability, or at least from which a reasonable juror could conclude that Jeff Jessup was a qualified individual with a disability. Mr. Jessup had went out on leave in July 2017 due to anxiety, severe anxiety, and major depression. He requested a reasonable accommodation when he went out, and that request was denied. However,
What was the accommodation you requested?
a leave of absence. He requested a leave of absence. And he submitted medical certification in support of his request for leave. And again, it was denied. Now, although it was denied.
I'm missing something on that. He got benefits, didn't he? And this is July 2017.
That's right. He got short-term disability benefits.
And he was allowed to return.
Well, he did return, Your Honor.
I understand, but I'm talking about, you said he was denied an accommodation in July, and I want to understand what you're saying. So what was the accommodation that he was denied? When you say a leave of absence, yet he was allowed to return. Now, is there a distinction?
Well, no, Your Honor. He requested the leave of absence. They denied the leave of absence, told him that he was terminated and would not be allowed to return.
July?
They denied his leave of absence in August.
They didn't terminate him then, did they?
No, they did not.
Okay, they terminated him actually in January.
In January 2018.
Yeah,
Well, they
No,
initially, they
earlier.
wrote him a letter and terminated him,
right.
said you're fired. And then
November.
that's November timeframe.
That's correct.
And then he, despite that, he sort of comes back in and pretends to work for a week, and they finalize the process in January.
Well, again, and I would take exception with the court that he pretended to work. There's nothing in the record that anything he did was pretend.
Well, but I mean by pretend, I don't mean that he didn't do work, but he had been fired already.
Well, and I don't think that's the case. I think
I thought you just said he was fired. The letter fired him in November.
No, the letter notified him that he would be fired, but he was not fired.
It was in the future tense. You will be fired, not that you're fired.
It said the company has made the decision to terminate your employment, but then they took no actions to effectuate the termination. They left him on the payroll. He remained connected to the IT.
He didn't do the work. In other words, their internal memos said, we want to preserve his benefits.
That's right.
And so they did not follow through and call his card back and stop pay while he was getting benefits.
That's right.
But then they wrote the letter in January and said, we're confirming our termination of you in November.
That's right. After he returned to work, they confirmed.
Well, not on there. They didn't accept him back to retreat. He went on the computer, but they didn't accept him back because when he went back and claimed he's coming back, they said, no, we terminated you in November.
Well, again, he returned to work. He worked for an entire week. He took a certification class that was necessary to return to work. 30B6 HR witness confirmed that he had taken the class that was necessary to return to work. He participated in conference calls. He interacted with.
This had to all get this return, this 1 week return.
Yes.
Got into the system and got to HR, and they said, we fired him, and they sent a letter confirming the fact that they had fired him. But let me raise a point in this regard. This has obviously got some ambiguities about it based on the facts you've pointed out. But in his complaint in paragraph 37,
Yes, Your Honor.
He alleges basically that he was permanently totally disabled. That, of course, is just an allegation. He argues now that he went back in January, and so he wasn't permanently. But then he gives his deposition in December of 2019, and he's asked about paragraph 37. And he says, that's true. And over several questions, he affirms, I am totally disabled, and I have been told so by my professional. And then the record contains a report in August of 2018 that says just that, confirming 37. So now the district court says he alleged it in his complaint. He sticks with it under oath, uncompromisingly, unconditionally in December of 2019, and it's supported by a medical record. How can he now allege that he could go back to work?
Well, let me start by saying I don't know what medical record you're referring to.
Well, there's a report on August 10, 2000. No, that's not the report. There's a report in May of 2019.
But you don't need a report.
You don't need the report.
Okay, so let's take the allegations in the complaint. And I would just suggest that the allegations in the complaint do not say that he was disabled and never able to return to work after July 2017. That's not what these allegations say.
It says plaintiff has not been able to recover from this debilitating relapse into severe anxiety and major depression, and is now fully and completely disabled and unable to work.
That's right. And so when this complaint was written in August 2018, he was fully and completely disabled. He had
All right,
not.
Now let's move forward. And he was asked.
Wait.
Yeah.
But that he was unable to recover and implies then not just at the time it's filed, that's saying since July to the present, he's been unable to recover.
Well, he's been unable to recover from anxiety and unable to recover from depression, and now is fully unable to work. The idea that anybody that has depression or anxiety is therefore permanently, totally, and completely disabled is not what we're alleging. What we allege is that he, and this is in paragraph 35, the discriminatory treatment was severe and pervasive, resulted in a hostile work environment, caused plaintiff to relapse into debilitating anxiety and depression, and necessitated a need for a reasonable accommodation in the form of leave of absence.
What about his deposition testimony?
Okay, well, his deposition testimony, quite honestly, he didn't answer the question. But what he said was, when he was asked about the date of his disability, he made reference to the Social Security finding that was the date of his Social Security.
What page is that on?
197, 198.
Thank you.
But before that, there's a series of questions. He's asked if when he became completely disabled and unable to work. And he says, I think after the hostile events that occurred between April 3 or 1st until I went on leave again on the 19th. I think the things that had occurred in that box have created an anxiety towards employment. They then asked, since July 2017 to December, how you are fully and completely disabled and on work. That's been affirmed by Social Security.
Right. And it was affirmed by Social Security because Social Security has this concept of unsuccessful work attempts.
You want us to read that answer as him saying, Social Security says that I'm disabled, but I'm not disabled, or I haven't always been disabled, or I'm not disabled when I don't want to be disabled.
Well, you have to read it in light of the fact that he actually returned to work. Let me make this point. If I was standing here today saying Jeff Jessup was totally and permanently disabled on July 19th, 2017, the first thing I would hear was, but he returned to work. The next thing I would hear is, and the medical.
And the return to work you're talking about is after he's fired, when he logs onto his computer and listens to phone calls.
Yeah. What I would say is, again, I appreciate your conclusions of fact, but in a light most favorable to the plaintiff, he returned to work. He did his job. That's the standard we're here. I understand that there may be some skepticism, and there may be some skepticism on behalf of a jury. But if we're going to take the standard that is required, then he returned to work. And not only did he return to work.
So in essence, you're basically saying your claim depends on his ability to respond to emails and listen to a phone call from home after he was told he was fired, that being able to slip that in ensures that that's the point that means you win because summary judgment is inappropriate.
Well, again, didn't slip it in. He returned to work and he did his job like many people have done their job over the last year from home. And again, the idea that all he has to do is sit there and listen on the phone and do some of these things, that again can be a cynical view of what took place, but a view that is compelled. That is the view in a light most favorable to Jeff Jessup. He returned to work and did his job.
But that's only so if he's able to do that.
Well,
if
and
you fire a person, right? You fire a person,
Mhm.
you fire a secretary who's doing a terrible, terrible job. And she comes back 3 or 4 months later and decides to type.
Yep.
She can't make that decision. You are the authority that decides whether she works for you or not.
Right.
It doesn't matter how well she types or how much work she does.
Well, the question becomes, was she fired?
Right, but he was fired
How do we know that?
because we have it in the record.
No, we have a letter that says you're being terminated and nothing else. We've got substantial evidence in this record.
A letter when he came back,
That's right.
and he's fired too. And
No.
what does it say? It says we confirm that he was fired November 17.
No, what it says is the date of the letter was January the 8th. Now, of course, January.
Let's give you the 13th, the 12th or 13th, whatever it is.
So
Okay.
it's backdated.
Yeah.
In the letter, and I was looking for the citation to that letter, it says that you went out on leave in July and you have been on leave ever since. That's what the letter says. So I'm going to pull the letter.
Read the part where they said we fired you.
680. So JAC, let's see.
Here it is. At that request, this is a historical basis. I'm looking at 310. On October 17, you were forwarded to us a note from your healthcare provider stating you needed additional time. At that request was not reasonable. As that request was not reasonable, given the nature of your job, you are terminated from your job on November 7th. You were terminated on November 17, and again through a letter from our attorney to your attorney. This letter is official confirmation of your termination, effective November 17, 2017.
And so if you ignore.
Now let's take this, let's accept your point. This is the termination letter.
Okay, well.
Doesn't matter. He was terminated
And
because he
again,
wasn't qualified. That's their point.
I understand that.
December, a year later after these events, he's asked, was paragraph 37 true at that time? And he said, it is true at that time and still is. Didn't he say that?
He testified that it was true at the time he was testifying.
Question is,
And
was that true at the time this complaint was prepared and filed back in August of 2018?
yes, it was.
It is, and it was true at the time, and it's true as of today, Now, how clearer can it be?
On the date of his deposition, he's saying that I am unable to work.
It's been plain, he says.
The complaint was drafted 6 months after he was fired.
I understand the complaint was drafted, the complaint was filed. The complaint was filed in August 2018. He gives his deposition, that's paragraph 37.
That's right.
Various statements that he says in deposition, that says in his complaint that he is fully and completely disabled and unable to work. It's true then, and it's true now. So what you're saying is that he was able to work, though, back at the time when they purported to fire him. Is that what you're saying?
That's right. He was.
Okay, I'm glad to hear that. I'm now understanding your argument. But what does that get you if he is now permanently disabled?
Well, it gets, again, if their conduct, and I've got evidence from treating physicians and other psychologists that they're discriminatory.
Not fully, you're putting words in.
He was not able to recover from this debilitating, but it didn't, and my point is, but he did return to work, and we've got.
No, just a minute. Now, this complaint is filed in August of 2018, right?
That's right.
That is after that period of a week when he returned, right?
That's right.
So the complaint seems to suggest from July, when he left work disabled, to August 2018, he has remained disabled.
And that's not.
That's not what that says?
No, it is not.
All right. Thank you. All right, we'll hear from Mr. Bright.
Mr. Bright, sometime during your argument, I would like you to address what I now take to be his argument that he fleshed out for us here. I had not.
I'm going to respond to that initially, if I may.
Okay, great, thank you.
My name is Tom Bright. I'm with the Ogletree Law Firm out of Greenville, South Carolina. It's my privilege to represent the Barnes Group today. And John, I want to address your specific question. I think your question was, do you concede that he was unable to work now and in the past? And the question was, I think, was he unable to work? And what do we do about that issue in January when he says he reported to work? The bottom line is none of that is relevant. What we have is his deposition testimony and his complaint, which have the benefit of hindsight. That was done in August when the complaint was filed. And we are also talking about December 2019 when his deposition was taken. So with the benefit of hindsight, when asked the question, when did you become disabled? He very clearly and unequivocally states, since July 7th or 19th, 2017, I have been unable to work. It doesn't matter what he did in January or who wrote him a letter in January or anything else. He has told us in no uncertain terms that since July 17th, I have been totally incapable of working.
And when did he say that?
He said that in his deposition. He said, as you've quoted, I've quoted the deposition testimony at
197?
197 of the record. We also have, of course, the complaint, which is the joint appendix at 23. And what's important is I continued in his deposition to push him on that issue. So I asked, so that would be since July 17th or July 2017 to today. Judge Niemeyer, I asked him the exact question that you're asking. From July 17 or from July 2017 until today, which was the date of his deposition, which was in December of 2019, which is now 2 years removed, with the benefit of hindsight, you were fully and completely disabled and unable to work. And Judge Richardson, his response was, that's been affirmed by the Social Security Administration. Now, I don't know how
his argument, to give it in the light, the best light I can, what his argument is what he's avoiding your question, right? And so that we ought to, there's a dispute of fact as to his claim would be, as to whether that should be read instead of saying, I think it's most naturally read, yes, comma, that has been affirmed by the Social Security. He suggests, which I think is how we're reading it, or you're suggesting it's read. He wants it to say instead that I'm not answering that question, but the Social Security Administration says that I'm disabled.
Right.
And so tell me why we shouldn't read it. I mean, he's trying to say there's a caveat there that he's not answering the question, but instead is just saying, I'm not going to tell you the answer to that. I'm instead just going to talk about a football game, which is irrelevant.
And I think that I understand what you're trying to get at, but let's look at the question. The question says, so since July 2017 until today, you are fully and completely disabled and unable to work. He says, that's been affirmed. Let's stop there. Isn't that an answer to the question? That answered my question. Now he added, well, and Social Security as acknowledged it too.
Actually, I think he does a better job at the top of page 197, where the question is, paragraph 37 of the complaint says that you have been unable to recover from your debilitating relapse into severe anxiety and major depression, and now are fully and completely disabled and unable to work. You have, so going back, you have been unable to recover and still are. And his answer is that's true.
That's right. And again, I think that.
And this is in December.
That's right.
And the complaint covered the week, as did his deposition covered the week.
I agree with you 100%.
Well,
All right. So, but his best story there, I'm not saying it works, but I just want to make sure I understand your position. His best story there, I think what he's trying to say is that when he says, I have not recovered from my debilitating injury, what I mean by that is that I've had this debilitating problem, but for a week in January, we should implicitly read in, but for a week in January, I was healed. And so I was fully capable of working for that week. Even though I still had the injury, I was able to work during that week despite the debilitating injury.
And I would suggest to you that that's not the question that was asked, and that's not the question that was answered. The question that was
I
asked.
think his theory, just to carry on exactly what Judge Richardson was posing there, I think the theory is I was in fact recovered in January, and I went to work based on that, and I have some medical support for that. And that I was then fired at that point because the employer didn't want me back, and the firing itself caused disability again.
Again, there's no allegations in the complaint at all regarding that theory.
I'm trying to understand both sides here. So,
And I am remiss to try and make too much of an argument when the questions have been the way they are. But again, to respond to Judge Richardson, I say, again, I go back to the question. So that would be since July 2017 to today. You are fully and completely disabled and unable to work. He could have answered, no, there was a period in January that I was able to return to work. That's how he could have answered the question if that was in fact the truth. But with the benefit of hindsight, as we were sitting there in December of 2019, he said, that's been affirmed. In other words, yes, I've been totally and completely disabled.
See, his problem, or what I think the argument would be, yeah, the Social Security Administration said that, but he's not claiming that that's correct.
Well, and again, I don't mean to be disrespectful, but I think that the answer to the question is that's been affirmed. He's saying, yes, I've been disabled. And
no, he's saying that someone has held that he's been disabled.
Well, he could have said, well, according to the Social Security Administration, they think.
I think, well, okay.
But I think what he said is that's been affirmed. He was answering my question.
I think the reality is there is a hedge there of some kind. He could have said, yes, that's true, but he put it off. It seems to me at the top of page 197 is a clearer indication of what he's saying.
Agreed.
But
Agreed.
You tried to pin it down to have the continuum, and at that point he hedged.
I couldn't disagree with you with your characterization of that testimony at page 197.
Is the question, so I'm just to make sure I understand the question. The question we're asking, is it fair to say that the question we're asking is whether a reasonable jury could read that testimony and conclude that it means what your opponent thinks rather than what it is most naturally read to mean?
And I think when you take the testimony in context with the complaint, you take that testimony in context with the other language of the other questions that we asked on page 197, I think it's abundantly clear. He was saying
But
that
the
since
district
July,
court
I've
went a
been
different
listening.
route, instead of asking whether the jury could reach the conclusion, the district court went the route, and maybe that's the issue really before us, that this is a judicial estoppel. In other words, he has said it in the complaint and he said it in his deposition. I'm relying on it and throwing it out. He cannot now change his story.
I think what the judge was relying on was the fact that these facts that you have been referring to about him returning to work, about him coming in and doing certain things and answering phone calls, all came in by way of declaration that was filed not in response to summary judgment, but in response to the report and recommendation of the magistrate. So after summary judgment has received a report and recommendation from the magistrate, they submit this declaration that says, oh, by the way, here are all the things I did in January when I returned to work. And what the judge was saying is, we can't allow a plaintiff to create an issue of fact by contesting his own testimony. His testimony, as you pointed out in page 197, was abundantly clear. What he attempted to do by way of declaration and in response to the report and recommendation of the magistrate was say, oh, well, wait a minute, there's some things I did in January. Let me recite to you what those things were. And the judge says, you can't use, and that's the significance of the Halpern decision, you cannot create an issue of fact for a jury by submitting testimony after the fact that is in conflict, direct conflict with your prior testimony. So the court basically ignored that declaration.
Well, but see, the problem is I think all of it trying to talk to you about is that his answer to your, which I agree with Judge Nina, the question on 197 is probably your best thing. And was that true at the time that this complaint was prepared and filed back in August of 2018? It is. It was true at that time, and it's true as of today. But he doesn't say it was true at every moment along the way. I think that's where
Well, and again,
But that isn't there. I think what you're saying is that to reach Judge Motz's conclusion, you have to ignore he has not recovered from debilitating injury, right? So if it's the plain import of a debilitating injury is one that like disables you from doing what you can do. And so read in context, no reasonable, reader of the English language would read that to mean there was a point in which I recovered enough to work, but
yes,
not now.
Right.
that's exactly
But
right.
it doesn't quite say that. It doesn't say, and in every moment since then.
Well, that's right. But, we read things as reasonable readers of the English language.
Unless the court has other questions for me, I have nothing else to add to my argument.
All right, thank you, Mr. Bright. Mr.
Thank you.
Arnold. Could you just briefly address, I know it's a little bit of a collateral point, but how we should take the affidavit filed after the summary judgment motion is submitted?
Yes. So let me just make the point, because I've looked this up in the dictionary. Debilitating does not mean disabled. It just doesn't. So we're going to get into the English language.
Well, what is everybody talking about? That's very sophisticated. I mean, it seems to me the whole issue, he left in July because he couldn't work at that point.
And needed to leave.
And he needed a rest or whatever to get rid of the stressors and that type of thing. And he alleges in his complaint that that's the condition I had and I've been unable to recover. And so then he's asked at his deposition, is that true? Have you been unable to recover? And he says it was true then and it's true now.
And it was
But
true
the,
then.
yeah, but the gap between then and now is filled by the question, which was unable to recover. And now, sure, that's being technical too, but that's exactly what the language says. Now, my point is more of a procedural one, and that is you submit a motion, you brief, put everything before the court on a motion for summary judgment, and a magistrate judge comes up with a recommendation. And in response to the recommendation, you now add a new argument, and which is I wasn't disabled for at the time of that January week.
So first of all, we didn't add a new argument. Understand this, Jeff Jessup's deposition took place the day after the 30B6 deposition, which I asked question after question after question about Jeff Jessup's return to work. This was not something that was thought up. The EEOC charge was based on the fact that he returned to work. So as for the declaration, the rule related to R&Rs allows the district court to take additional evidence. I will contend that that declaration doesn't contradict one thing in his testimony or one thing in the complaint. It explains it. But even if you exclude it, then you've got to say, well, what about this idea that he returned to work? And the thing we haven't mentioned, we've got
Where's the record show that he returned to work?
his testimony.
Do you know what page?
Well, I can,
The week.
Oh, the week. Oh, okay. Yeah. Okay.
the week. And so what Halpern says is that if the only question of fact is between the complaint and the testimony and the declaration, and those two things are inconsistent, which I don't think they are, but let's say they are, then I lose. But that's not what we have here. And the thing we haven't talked about is the medical certification at JA 297 that says he is fully able to return to work. We have to ignore that, or we can read his answers in the context of the facts.
Is there a report attached to that statement?
Yes. I mean, they provide a form. Aetna provides a form. She completed the form and said that he could perform full duties without restrictions.
Yeah, where is the analysis of the, is there a report of the visit that the doctor had with him?
No, she completed the report that was provided by.
Just one statement, that one statement she gave.
Well, there were multiple statements. Again, if you look at 297 is where the form is at. And she states various things. She gives I'll leave that to you to see, but again, it is not just one line, he can return to work. And again, my point is that if he were contending he could not, that he was unable to work after July 19th, 2017, this document would be thrown in our face and you say, well, how can you say he was not able to return to work? You've got a doctor that says he could fully return to work. In addition, Dr. Ladd, who's at JA 711, says that it was his termination in January 2018 that made him unable to work. The last thing I want to make sure
So
you
is he
don't.
unable to work today because of the termination?
Right.
He is. He's unable from this, and when did that happen?
Well, he attempted to look for other jobs, but he was never able to go to work. And his healthcare providers said, we do not think you're able to work.
Okay, and so.
January, after January 2018. Now, let me say one more quick thing.
Your claim, your representation is that there is only that 1 week where he was able to return to work. And that after that week was over, he was unable to work. And before that, from July to January 8th, he was unable to work. But that week, he was good.
He was good and may have continued to be good if he had not been terminated.
So was he paid for the week?
I don't think that's in the record. I'll tell you what I do know is in the record is that his short-term disability benefits were terminated when he returned. That form that he returned stopped his short-term disability benefits.
Yeah, but weren't they trying to get him benefits, as Judge Niemeyer has talked about earlier?
They were trying to get him to leave. But let me say this one last
Well,
thing.
they were
'Cause
trying to get him benefits too.
no, they just were trying to comply with their plan.
Well, but that was getting the benefits.
Well, sure.
Yeah.
So the thing I would want you to add is, even if he was unable to not work after July 2017, that has nothing to do with the hostile work environment claim. The qualified individual disability, he was qualified individual disability between April and July, when the hostile environment allegations are alleged. So you can't say that, hey, he was disabled on July 2017, and therefore all his claims are affected by that. It would only be those claims, the wrongful discharge claim that we allege arose in January. The hostile environment claim, the court said, well, you got to be a qualified individual with a disability. Well, during the period of time that we allege that the hostile environment was created, it is undisputed that he was a qualified individual with a disability because he was there doing his job. So you can't just take that one date and apply it to all the claims. And I addressed that in my brief. And since I'm over time, I'm going to be quiet unless you have any other questions.
All right. Thank you, Mr. Arnold.
Thank you.
Our practice, as you all know, is to come down and greet counsel, and we suspended that during the COVID period. And for purposes of safety, we're continuing that, but don't think we've abandoned that. We appreciate counsel's arguments, and
We understand.
and it's a grand old tradition. And I promise you, whatever good a promise is, to shake your hands the next time you come up to court. Thank you very much. We'll proceed on the last case.
Should I begin, Your Honors?
They're in video.
Oh,
Maybe not quite yet.
last
Gonna let
case.
them clean.
We're going to excuse counsel here. Can you hear me, counsel?
Yes.
Okay, we're going to excuse counsel and are presently in the courtroom, and they'll be right with you.
Okay, thank you, Your Honor.
All right, I am now going to call a case of Velasquez versus Garland, and I guess Ms. Smallwood, do we hear from you first?
Yes, Your Honor.
Okay, you may proceed.
May it please the court. My name is Evelyn Smallwood, and I represent Catherine Mejia Velasquez in her petition for review of an order of the Board of Immigration Appeals pre-termitting her applications for asylum, withholding of removal, and relief under the Convention Against Torture for failure to provide biometrics as required pursuant to 8 CFR section 1003.47 and of an order denying her motion to reconsider. The primary issue in this case is whether the agency's interpretation of 8 CFR section 1003.47 is entitled to our deference. The court should hold that it is not entitled to deference because it is unambiguous according to its text, structure, history, and purpose. Even if deemed ambiguous, this court should still hold that the agency's interpretation is not entitled to our deference because it is not a reasonable interpretation of the regulation and it is not within the zone of identifiable ambiguity. Also at issue in this case is whether the IJ properly followed current agency policy when pre-termitting Ms. Mejia Velasquez's applications. And this court should hold that the IJ did not. I will proceed as follows. First, I will show that the regulation is unambiguous.
Counsel,
Yes.
Judge Motz has a question.
I'm asking you questions.
Oh, I'm sorry, Your Honor.
That's all right.
Yes,
So just let me ask this lead-off question.
sure.
Did the IJ give her the opportunity to show good cause?
He did not, Your Honor. If you look at the transcript, which is in,
Undisputed that he's required to do that, right?
yes, Your Honor, it is, according to the regulations and according to the current agency policy. So however this court decides as far as the ambiguity or reasonableness of the regulation, it still remains that the IJ did not allow respondent an opportunity to show good cause.
Let me ask you the notice that the IJ gave her, which is in the appendix. It's that yellow sheet,
Yes, Your Honor.
fingerprint warning. Does the government contend that was the notice?
I don't want to speak for the government, Your Honor, but it's my understanding that this fingerprint warning is something that is specifically generated by this judge and provided after the government has provided the fingerprint instructions that are in the administrative record at AR 37. So AR 37 is typically the document that is used by the government.
I wanted to focus on this document, that the fingerprint warning. Did that cover what a notice would require generally?
It is our, Your Honor, it did not. And the reasons for this is because number one, the regulation requires that the Department of Homeland Security be the one who notify the applicant of the need to provide biometrics.
Was supposed to provide that, and this judge provided something. It's ad hoc or whatever he's doing. But
yes,
let's just and I'll present this question also to the government. But this fingerprint notice says it was the hearing was, I think, February 7, and was given to her at that date. And it says you have 45 days from this date to provide the fingerprints, right?
Yes, Your Honor.
Well, the next hearing was about 33 days or 32 days later, and that's when they threw out the case.
So the next hearing, Your Honor, is in March of
Was it the hearing on March 12th?
Of 2018, Your Honor. So it was actually a year.
I've got that. So they did give the 45 days then. And in other words, that is sufficient. And is there anything substantive in that notice that is lacking?
Yes, Your Honor. So we would point out that this notice is not a biometrics notice. So it is not a document that allows the respondent to enter into the application services center, support center, in order to provide her biometrics, which the regulation requires the department to give. In addition,
I'm misunderstanding that. I thought the regulation says notice of biometric.
Yes, Your Honor. So looking at ACFR 1003.47 at section D, it says that DHS shall notify the need to provide biometrics and other information, and shall provide a biometrics notice and instructions to the respondent.
Okay, let's set aside the instructions for a moment. It says, and provide a biometrics notice, right?
Yes.
Is there anything that prescribes what has to be in that notice except just simply notice?
Yes, Your Honor. So first of all, because it says notify the applicant and separately says a biometrics notice, then the regulation does separate the notice with, the notification of the need with the notice.
I'm trying to get at the question of whether this fingerprint warning substantively advised your client of the biometric. Was this a biometrics notice, even though it was given by the judge instead of DHS?
You maintain that a biometrics notice means a separate piece of paper which has on it a physical notice of the date and time to have the fingerprints. Isn't that your contention?
Yes, Your Honor. And that information is found in the Federal Register.
Understand, I want to focus on this document at page 196.
Yes, Your Honor.
And I want to know whether that functionally served as a biometrics notice.
No, Your Honor. And the reason for that is
I want to
because
know why not if it didn't.
Right, because looking at the Federal Register, it says that the biometrics notice shall have the alien registration number, the receipt number, if any, the name and the form number. In addition to that, the biometrics notice, as is understood by the regulated public and is discussed often in the record by the department, is the document that allows the applicant to enter the application support center. So if Your Honor would look at the administrative record on page, I believe, sorry, Your Honor. Page 40, it specifically states that the applicant must have a DHS generated biometrics notice in order to enter the ASC and get the fingerprints notice. In fact, if you look at page, sorry, it's actually on that same page where it discusses that this notice that is provided by the immigration judge is not sufficient to allow an applicant to enter the ASC and to provide their fingerprints. And I would also like to point out that that document is, it does not include the good cause exception, which is necessary in order for the IJ to give proper notice. And it also is inconsistent with what the IJ states on the record. So that notice says that it must be done within 40.
The IJ and the BIA relied on the DMCP case.
Yes, Your Honor.
Which basically just it sort of eclipsed the regulation in the requirement for a written notice and instructions. And I understand that argument. I was just wondering whether the government is claiming that the notice that was given by the IJ was the notice referred to in the regulation or substantively served as that notice.
Again, Your Honor, and I don't wish to speak for the government, but it does not comply with the regulation under 1003.47, nor does it comply with the current policy.
That. What provision of 47D does it not comply with?
The part that says that it's the department who needs to provide the applicant with notification of the need to do biometrics, a biometrics notice, and instructions. And Your Honor, if you read further in section.
Ma'am, just stick with that. You keep jumping off the answer I'm asking for.
Yes, sir.
Why didn't that comply? And you said it didn't comply with 47D. Now I want to know why that notice didn't comply with 47D.
Because it is not a biometrics notice.
What is it?
It is as Your Honor stated, it is an ad hoc fingerprint warning that is produced by the immigration judge and handed to applicants in immigration proceedings.
All right.
Now, 1003.47 does require the immigration judge. It says that he shall specify for the record when the respondent receives the biometrics notice and instructions.
My next question is, did the IJ ever get confirmation that the applicant had received both the notice and the instructions?
So no, Your Honor. If you look,
I read the record and it doesn't have it.
Yes, Your Honor. So the immigration judge repeatedly refers to the biometrics instructions, and he never refers to the respondent being given a biometrics notice. In addition, we would just point out that the text and the structure here, it shows that a biometrics notice is to be provided, and once it is provided, the judge shall state for the record that the biometrics notice has been provided. And so those articles are important there because it indicates, as Judge Mott stated, that this is a physical document that is given to the respondent in order to allow them to provide their biometrics. We would also point out.
Can I jump back to I believe Judge Mott's question at the very beginning about the individual must be given, as I understand it, the opportunity to show good cause. And I understand your argument to be that we should read opportunity to show good cause as requiring the immigration judge to specifically inquire about the issue, as opposed to having a hearing where you say, is there anything else? Like you're in front of the judge, here's what the question is.
Yes.
Why is it that we read, I mean, normally we think of an opportunity to be heard as not requiring the judge to specifically inquire, about, do you have an argument on this? Do you have a First Amendment argument? Do you have a Second Amendment argument? Do you have a Third Amendment argument? Do you have a Fourth Amendment argument? Right? We don't require a judge for an opportunity to be heard to run a lawyer through every possible argument that could be made. And, there are several that could be made. Why do we not interpret opportunity to show good cause as a hearing where the lawyer could, if they chose, and maybe should have, right? But that we don't have that claim before us, but where they have the opportunity to show good cause. And why are we interpreting it so to require the judge to specifically ask the lawyer about the claim?
So two things that speak to that, Your Honor. First of all, I would point out that the judge, as you stated, he did say, anything else on the record. But he did not say this until after he had already pre-terminated the case. And so at that point, it is not appropriate for an attorney to revisit a decision that the judge has already made, particularly when the question is whether or not there is anything else that he would like to address. And we would just also point out.
All right. So, I mean, that's inconsistent with, how practice works in front of judges, right? I mean, judges make rulings and people are like, wait, judge, you didn't give us a chance to put on evidence, right? We wanted to call the officer on this Fourth Amendment claim. Oh, okay. You want to call the officer? Put him up, right? I mean, I'm just not sure that gets you anywhere. What you've got to show, I think, is that the key argument you've made on that point is that give opportunity to show means every immigration judge must specifically ask before pre-terminating in this context, do you have a good cause argument? And now is your opportunity to show it, that it requires specification by the IJ.
Yes, Your Honor. As to that point, we would just point to the general principle that immigration judges have a duty to develop the record in immigration court. And so in the context of immigration court, then yes, the immigration judge knows that the applicant has an opportunity to present good cause and to show the reason for not complying was due to the good cause exception, then the immigration judge has a duty to develop that part of the record.
And if they don't, your point, as I understand the argument, is if a judge does not specifically ask the lawyer about the good cause argument, then they have not provided an opportunity to show good cause.
Your Honor, I don't think that is necessarily the case. I think that looking at this specific case, that there was not an opportunity to show good cause. When you look at the transcript, the immigration judge, first of all, it appears that there was that the government spoke outside of the presence of the respondent. Then the judge asked the department for a motion. They motioned to pre-termit, the judge pre-terminated. And so in the context of this specific case, there was no opportunity to show good cause. And that was the immigration judge.
I mean, again, I get your point if it requires specific questions, but the judge says, is that true? The answer from a good lawyer, and I'm not saying this was a good lawyer, but the answer from a good lawyer, yes, Your Honor, but we have good cause for doing that, right? I mean, that's what lawyers do in response to questions.
Yes, and I don't disagree with you there, Your Honor. I would just point out that we only get to this question and to this issue if this is considered a reasonable interpretation of an unambiguous regulation, and we believe that it does not. But in addition to that, Your Honor, I would just point out that I'm sorry, I lost my thought.
Let me just ask you one more question. Did your client receive the instructions at the hearing?
Yes, Your Honor. We are not contending that she did not receive the instructions. And those, as I said, are the instructions that are found on page 37 of the record.
She did not receive a written notice, and the ruling that relied on DMCP, that she was given instruction, oral notice, was sufficient, is basically your challenge.
Yes, so that she received notification, but she did not receive a biometrics notice. And I know my time has expired, but if I may.
One final question, at least from me. So we've touched a little bit on in 47 about who provides the notice. And I didn't understand your argument in your brief, and I want you to point me to where I'm looking to suggest that the person who hands it is the problem. So that if it was an actual, what you describe as an actual biometric notice, the fact that it's physically handed by, in this case, Mr. Jones, whoever that was, that violates 47. Do you make that argument separate and apart from this is not a biometrics notice? Do you understand what I'm asking?
Yes, Your Honor. And so obviously we do make that argument that this is not a biometrics notice. But in addition, just looking at the Federal Register, I think is where that is actually more clear, which might be why Your Honor did not.
No, but what I'm asking is assume a hypothetical for me for a second.
Sure.
Assume the yellow piece of paper is a biometrics notice. I understand that this is not your argument. It's a hypothetical for that very reason. Assume that it is a biometrics notice for purposes of the question. Are you arguing that the fact that it was handed by the judge instead of by DHS, that violates 47?
No. Well, I would
understand you to be making that argument. I just wanted to make sure.
No.
I understand the biometrics notice argument. I just want to make sure there wasn't a separate argument that it must be handed by a particular person.
If I may point Your Honor to the Federal Register, it does say the DHS fingerprint notice will be hand delivered to the alien by DHS. And so the regulation does say that they will be given notification, a biometrics notice.
How about if the DHS leaves a stack of those forms on the clerk's desk and the clerk hands it to the applicant? That's okay, isn't it?
Right. So
I mean, that argument doesn't seem to have a lot of. It's hyper technical, isn't it?
Yes, Your Honor. And the idea is that the applicant be given a DHS created appointment notice that gives them the opportunity to enter an application support center. And I think that
is a copy of one of those in the record.
So there is one of those in the record, and that is at AR 13.
Sorry, I didn't mean to run that over.
That is the notice that is required by the reg. You say.
So it is not our contention that this is the notice required by the regulation, because as Judge Motz pointed out, this has the date and time, which if you look in the Federal Register, the regulation doesn't require that show the date and time, but this is the notice that the ASC currently. Oh, I'm sorry.
This is an appointment notice.
Yes, Your Honor.
Is that what you're contending the notice in 47D is? I want to know, do we have a copy of a 47D notice in the record?
So, Your Honor, a biometrics notice is used interchangeably with an ASC appointment notice, with an ASC biometrics notice.
How do I know that?
So that is in the record, even looking at the instructions.
I'm trying to follow the reg, and I'm trying to read the reg. We're trying to determine whether to give the agency some deference on what it's doing.
Yes, Your Honor.
And so I'm trying to find out, the reg uses the word biometrics notice. And you're telling me the biometrics notice was not given in this case. The one I pointed to was not a biometrics notice. And I'm asking you, is there a form that's called biometrics notice that should have been given? And if so, where is it?
So, Your Honor, there is not, because of the way that the agency currently interprets the regulation. I'm sorry, yes, which is the problem. So a biometrics notice is it when looking at in the context of immigration law and appointments, and there are examples of this in the record and in the brief. For example, at footnote 7, there is a it cites to in the opening brief, I'm sorry, it cites to a question and answer session with the asylum office, where the asylum office continually uses the term biometrics notice and AO biometrics notice to mean an ASC appointment notice, which is what the document at 13 is titled. So a biometrics notice for the court, for the respondents, for the department is the document that allows the applicant to enter the application service center to get her fingerprints.
All right, thank you very much. We'll hear from the government now. Ms. Browning? Can you hear me? Are you muted?
Yes, I was just unmuting myself.
Okay, fine.
Can you hear me okay?
Yes.
Okay. Thank you, Your Honors. May it please the court, Rachel Browning for Attorney General Garland. The record in this case confirms that the judge and DHS fulfilled their respective regulatory obligations. The IJ notified petitioner of a requirement that she be fingerprinted. The DHS provided her with a notice and written instructions for submitting her information to receive an appointment.
Where is the
notice? And the judge warned her of the consequences for failure to comply. I'm sorry?
I think that.
Where is the notice?
So the notice and instructions are one and the same. If you look at record at AR 37.
What is that? Show me in the record.
AR 37. And what it says is that in addition to filing your application and supporting documents, you must also complete the following requirements before the immigration judge can grant relief or protection. And then it instructs the applicant to submit the first 3 pages of their asylum application, a copy of their what's called a G-28, which is if they're represented by counsel, and it gives them the address to where to send those. Once the U.S. Citizenship and Immigration Services has that information, they send out the ASC appointment notice, because every individual, every non-citizen who applies for asylum, whether they apply as a defense to removal and removal proceedings, as petitioner did, or whether they apply affirmatively,
now
goes through USCIS to become.
Can you hear me? Can you hear me?
I think you maybe if you turn down your volume, maybe you could hear us coming in.
Sorry.
No, I think you got to turn it.
What?
All right. Anyway,
I
my
can't control
question
your
is,
volume.
I'm looking at this document, and I'm a applicant, and the question is, this clearly is these are instructions. Show me specifically where there's explanation of the notice, biometrics notice, and what has to be done on that form.
Okay, Your Honor, at the very top of the form,
Yeah.
in addition to filing your application and supporting documents with the immigration court and serving a complete copy of your application with the Immigration and Customs Enforcement, you must also complete the following requirements before the immigration judge can grant relief or protection in your case.
Okay.
That is the notice to provide biometrics.
If you go 2/3 of the way down or 1/3, after the 3 items are received at the office, you will receive, it says one thing. And the second thing is an ASC notice for you and separate application center.
Correct.
Where does it say, it tell you about the notice that we're talking about here?
The instructions are the notice. And when you consider that in conjunction with what
Where
the
is
immigration
where
judge,
is a casual reader notified that he or she has to get fingerprints on this page?
at the top of the page that says instructions for submitting certain applications in immigration court and providing biometric and biographic information to U.S. Citizenship and Immigration Services. And what the judge did, if you look at the transcript, is he said, you are required to submit fingerprints for biometrics. The DHS attorney is handing you the instructions for fulfilling this requirement. And keep in mind, petitioner was represented by counsel.
This says instructions for providing biometrics notice, and that's required by the reg. But the
Yes,
question is, I would think that a notice of biometrics says because of A, B, or C, you are required to provide fingerprints in accordance with the following instructions. And somehow, and the date and the time and by which you have to do it. Now, that's what I would think a notice would require some form. This is
Not that.
yeah, this is what I call
This is what-
bureaucratic instructions. So,
I mean, I can only speak for what the government does. This is what everyone receives.
well, I understand.
And in
The
fact,
whole
I
question
think
in this
it's,
case is whether what you're doing is in compliance with the regulation.
well, if you look at
And
subsection
you-
D of the regulation, it also states that, let me find it. That whenever required by DHS, the applicant shall make arrangements with an office of DHS to provide biometrics and other biographical info. So the regulations contemplate the fact that it may be necessary for there to be an additional step. It's impracticable for a DHS attorney sitting in immigration court to have an actual appointment notice for someone. I mean, these.
I'm not talking
depends
about
on where
an
the
appointment
individual
notice.
lives.
Ma'am, I'm not talking about an appointment notice. I'm talking about a notice in compliance with regulation. And that is a notice of a requirement to provide metrics, not the appointment, not carrying it out, not the instructions. The notice of telling the applicant she or he, in this case, she has to submit to fingerprints or to iris photographs or whatever biometrics are required by the government.
Yes, Your Honor, and our argument is that the judge did that in this case. He told her, he gave her the instructions. He also said that if she
That
did not
complies with the
comply,
first part of the regulation. He has to notify her, right?
yes, and he did that.
And the second, it says the DHS has to provide a notice, doesn't it?
It
in
says
addition
a
to
notice and
notifying.
instructions.
And instructions, right?
Yes,
Now, we, I guess, have a concession that the instructions were provided, although that wasn't confirmed on the record. And the judge simply said, you'll be receiving instructions or you'll be served with
he
instructions.
said DHS is handing you instructions. And I'd just like to point out that none of this was presented to the board in the first instance in her appeal. Her argument was never that she did not receive notice. Her argument was that the notice she received wasn't properly translated and that her prior attorney didn't explain to her what to do. And so the board addressed those arguments and said that in fact, if you're going to make an ineffective assistance of counsel claim, you need to do that. Otherwise, you're bound by your attorney's admissions. And she had more than 1 year. If there was something
The board
she didn't
relied on the oral notification given by the IJ.
Yes, that's correct.
A board did not basically eclipsed the notion that a notice had to be provided. And the implied conclusion is a notice of biometrics is different. I mean, is the same as notifying. That's the way DMCP seems to construe the regulation. And so that I think the whole issue is whether DMCP has properly construed the regulation, because DMCP supports you. It was complied with. The question is, was the regulation complied with?
I believe it was, Your Honor. And I just want to point out in DMCP.
Can I ask a question? I'm not sure. I'm not 100% sure I'm following. So why don't I think about this as the yellow piece of paper that Mr. Jones, who is the DHS attorney, the judge is putting on the record, right? Mr. Jones is serving your client with biometric instructions, right? In the present tense, right? Just like we often say in court, may the record reflect that I am handing this document to the witness,
Yes.
right? That I'm serving your client, and that the yellow piece of paper doesn't need to be, but in this case satisfies that DHS is providing a notice of biometric information, a biometrics notice to the client in this particular context. Why isn't that the notice here That might not be true in every case, but here we have an actual physical piece of paper that serves as that notice.
Well, I mean, first of all, my record is black and white. I don't know what's yellow. And this particular judge, as petitioner's counsel pointed out.
They refer to it as yellow?
What?
Didn't the IJ refer to it as yellow sheet?
Yes, I'm saying I don't know that it made it into the record because these are things that the petitioner takes with her.
All right,
And
so,
then submits, so it's not going to
knows the piece of paper we're talking about. It doesn't have to be yellow, right?
Correct.
It's described as yellow. I was trying to use shorthand. I
Right.
mean, if it help, I'll give you the JA site. But what I'm talking about is the piece of paper that everybody knows we're talking about.
Right.
When that is handed to her by the DHS attorney and the court puts on the record, you're being handed this piece of paper. Why is it that the notice? And it might be true in a different case that notification is sufficient. But in this case, we have a physical piece of paper. It doesn't include an appointment date, but at least hypothetically, you don't need an appointment date. You just need a piece of paper that's a notice. Why isn't that the notice?
I think it's encapsulated in all of these other things. I mean, without seeing exactly what's on the paper itself, but that in conjunction with the instructions and the judge's oral advisory.
Can you hear me?
Yes.
Somehow we have to figure out where I can ask the question, get my question in, but look at JA 196. And I want to ask you whether your position is this satisfied. This was a notice complying with the regulation or not.
$196. Do you have, I'm sorry.
I'm
You don't
looking
have
at
the same record?
I'm looking at the
I think there are two records in this case for reasons that aren't totally clear to me.
I'm looking at the JA.
Okay, I'm sorry, I don't have the joint appendix in front of me. I've got multiple.
Adopted administrative record, which is a strange phenomenon.
AR1. I mean, that's how I called it. There's another AR.
Oh, the AR2 is what I had. Okay, AR1. Let me see. Is it on 196 also?
Well, I don't know what you're talking about.
It's that notice, a green yellow sheet.
So in AR2, what you're looking at 197?
I'll see what it is. I want her to look at that.
It doesn't go up. I don't think. Yes, it
196.
196 of AR2, the second.
Yes, it says fingerprint warning.
Yep. I want your position. Oh, in AR1, it's 146.
Okay, I think I have AR2, the 1628. Yes, I mean, those are the regulatory requirements right there written. Failure by respondent to
My
follow
question
instructions.
is it your position that that is a biometrics notice that complies with the regulation?
Yes, in this case, it would be.
And what is
Not
your,
everything that the regulation requires.
and what is
And
your,
again, petitioner's argument to the board was not that she didn't receive sufficient notice. It's that she didn't understand what it meant.
well, yeah, but the reasons adopted by the BIA are the problem, I think, in relying on DM. They didn't rely on this notice. The BIA did not rely on this notice, neither did the IJ.
Well, the BIA looked at what DMCP requires. And first of all, I just want to point out that in DMCP, the board was not being asked to construe any ambiguity, alleged ambiguity in the statute. In that case, it actually found that the judge did not comply with his requirements or her requirements of providing the necessary warnings and the time frame in which petitioner had to comply. So the board was not put in the position of having to decide whether the procedures themselves were sufficient. It looked at the procedures that DHS had in place and the regulations and found them to be entirely consistent, such that the judge had not met either of the requirements, that he didn't do what the regulations were said. And in that case, petitioner had submitted her fingerprints. The problem was that DHS had not processed them, and then the IJ faulted her for not having completed. In this case, she never even submitted. She didn't follow the instructions and contended that the reason she didn't is because they weren't translated, and she faulted her prior attorney. And again, if this were really an issue, then it is something that she should have brought to the board's attention. So DMCP, the reliance on DMCP, I think, is a bit misplaced. under these circumstances.
Well, both the IJ and the BIA quoted 3 requirements to satisfy the reg. And the 3 requirements do not include a written notice of biometrics. And it seems to me that was what the BIA relied on. And the question now is, you're arguing that that is just a summary. It's not inconsistent with the statute, with the reg, but you're also arguing that in substance, the applicant in this case received both the notice and instructions.
And you're
Yes,
also
we did.
arguing to make the argument.
Yeah.
Pardon? We're arguing that she received all of the regulatory notice she was required to receive. And she had 13 months in which to figure out what to do. And so the regulation is stated mandatorily, if you do not comply, that will constitute abandonment of the application. And it puts the burden on the petitioner to fulfill these requirements, not DHS.
Isn't the agency required to give her an opportunity to show good cause for failure to do this?
I think the way that the regulation is worded, first it states that, failure to comply with the biometrics requirements, and I'm reading subsection C, within the time allowed by the IJ order constitutes abandonment of the application. And then it says permissively, the language changes to permissively, the judge may dismiss unless the applicant shows that the failure was the result of good cause. Or that there was good cause for failure to do that. I don't think that places an extra requirement on the judge, as Judge Richardson suggested, to point out, to ask the specific question. And in fact, petitioner's counsel had the opportunity. He could have explained if there was something to explain. And I think it's very interesting, if you look at the record, when the judge first asked petitioner's counsel whether she had complied with the biometrics, he says, in discussing the matter with her now, it appears that's accurate, that she had not complied. So it's pretty clear from the record that she didn't tell her counsel that she hadn't complied, or for whatever reason, he didn't know. And whether that was the fault of prior counsel or petitioner herself, that's not in the record. So there's a pretty big gaping hole for those 13 months regarding what happened. And I don't think, so that the fault should not lie with the agency in this case. She was provided all of the notice she needed to comply. If there was any failure on the part of her prior counsel, she should have raised that to the board. And if she didn't understand, but she has not done that here. So on this record, there's no reason for the court to visit DMCP. And, to the extent that the court believes that it's relevant, we would say that, as the board did, that it's consistent with what the regulations require. And so in this case, the petitioner had all the notice she was due and failed to comply. And so that constitutes abandonment of her application.
Can I ask you a question? Does the DHS have a formal form called Notice of Biometrics requirement?
That they supply an immigration court, I don't know. I've never seen one, because it's not, like I said, it's not something that would end up in the record. I assume it's probably the case that each court handles it differently.
Well, except the DHS has the responsibility of doing it under the reg.
Correct. And that was done in this case.
Here the IJ did it on your behalf.
No, the IJ says that, the IJ gave the oral notice and then indicated that DHS was providing the written instructions for compliance.
Well, what about the notice that I'm concerned, the instructions, let's leave those aside. I'm concerned about the Notice of Biometrics requirement. And I gather this one came from the DHS and was supplied by DHS attorney. Is Mr. Jones the attorney?
I'd have to go back and double check at that hearing. I believe so.
Mr. Jones is the attorney, and Mr. Jones is the one that hands the piece of paper we think it was probably created by the court, but DHS is the one that hands the paper to the client, right?
As I understand it, yes.
So other than the paper we have in this record, you don't have a form, a printed form with a number and so forth from DHS?
No, because whatever DHS would give to petitioner, they would take with them and submit that with their application to USCIS, and that goes into a different file. That's not
my question, ma'am. My question is, the reg requires a notice be provided. And my question is, in addition to notifying orally, so my question is, do you have a notice, a DHS form notice?
No, I'm not aware of one. In
All
this case, and in most cases, the notice is in the instructions.
All right. Thank you very much.
Thank you.
We have some rebuttal by Ms. Smallwood.
She's way over time. The other.
Yeah.
that doesn't have to be.
You're muted. You're muted.
My apologies, Your Honor. I would just like to point out, looking at AR 196, that this is addressed specifically by USCIS at AR 40, where it says, at least one Charlotte judge has sometimes given out this scary looking notice telling the client to take prints within 45 days. But this is not an ASC notice. The ASC will not honor it, and it has no effect. So our argument is that that is not a biometrics notice, because it does not.
ASC notice, counsel. I mean, the ASC notice is the appointment notice.
Yes.
Right? And I understood your argument. And there seems to be there are multiple arguments, but I thought your argument earlier was that a biometrics notice must get you into a fingerprint center, right? You must be able to go get your fingerprints with it.
Yes, and those fingerprints occur at the ASC, which is why ASC appointment notice, biometrics notice are used interchangeably. And as I said, there are examples of that.
Argument, counsel, are you making the argument? I guess that there's a separate argument. So that's one argument. I totally understand that one.
Yes,
is there a separate argument that it has to be in writing, right? So imagine instead of what we have here, a hypothetical where the DHS agent or attorney, I'm not sure it matters, like stands up and with the translator, reads out, your appointment is on December the 7th at 8:03 p.m. at this address. He reads it rather than hands a piece of paper. Would that constitute a notice?
So that it is our view that would constitute notification of the need to do biometrics, but it is not a biometrics notice unless it is a document, because that is what allows them to enter the ASC. And they can only do so if they have that document in hand.
I don't think that argument is supported by the reg. What supports the reg is that it has two clauses. One is that the applicant has to be notified during the hearing and has to be provided a biometrics notice. To give a notice. These two distinctions imply that one is in writing and one is oral.
Yes, Your Honor. I'm sorry?
I was going to say, anything else?
Yes, Your Honor. I would like to point out that the government claims that it would not be possible for the department to provide a biometrics notice to each individual in the court, and that is also not supported by the evidence. If Your Honors look at AR 42, that last paragraph, it talks about how previously ICE counsel would give individuals a fingerprint notice, advising them to visit an ASC on a walk-in basis. So this is something that has previously been done and can be done in those hearings. And then I would also just like to point out that the document that is on page 37 is the only document that the DHS gives an applicant in court. The only document that they gave to Ms. Mejia Velasquez. So she got instructions and she got notification, but she did not get a notice. And looking at that document, what it does is it puts this entire process.
She was given a yellow sheet too.
Yes, but that, as I said, that speaks to the IJ's responsibility under the regulation. And
IJ doesn't have that duty. DHS.
Under the regulation, the IJ has the duty to state on the record that a biometrics notice and instructions has been provided.
Well, I understand, but a notice, the reg says the notice has to be provided by DHS.
Yes, Your Honor. Yes.
And the question is, why is that not true here, based on the facts of this case, that Mr. Jones, whose DHS was representative, hands the piece of paper to your client, and the court says on the record, Mr. Jones, otherwise known as DHS, is handing you a piece of paper that happens to be yellow that includes all the information that is required. Why? That's what I'm trying to understand. Why isn't, in fact, that sounds to me that that's exactly what the reg suggests, right? The DHS hands you the piece of paper and the court makes note on the record that you're being handed by DHS notice, biometrics notice and information and instruction, sorry.
So my time has expired, if I may answer the question.
Yes.
I think there are two specific things that answer that question. And the first one is the Federal Register, where it says that this will be used to this is a notice that is hand delivered to them with certain information that is used in order to give their biometrics.
Yeah, and what's the second one? So I understand that argument that we should.
Sure. The second one,
what's the second argument?
So the second one speaks to the reasonableness of the interpretation. So the consequences of failure to comply with to provide biometrics is that the application is deemed abandoned, which is very dire, particularly in the asylum context. And what this process does using those biometrics instructions is that it puts the process entirely within the power of the Department of Homeland Security. So if the Department of Homeland Security does not provide the applicant with the biometrics notice, as occurred here, then she still has to be the one to face the consequences of having her application deemed abandoned. And it is not, according to regulation, the biometrics notice being provided is supposed to happen under the supervision of the immigration judge, which is the only way that would be, that's the only way that it would be reasonable to dismiss a case as abandoned, is if the IJ has confirmed that the applicant has all the tools necessary to comply with the biometrics requirements.
You were reading from the Federal Register. Is that in the record?
Yes, it was included in the 28J letter that we provided with the court. It's Federal Register Volume 70, entitled Background and Security Investigations in Proceeding Before the Immigration Judges and the Board.
Okay. Thank you very much. At this point, we would normally come down and greet counsel. You two are both quite remote. I don't know where you're speaking from, but it was we were glad to have your arguments, and we can't shake your hand for obvious reasons, but we do appreciate your arguments, and we'll adjourn court for the morning.
Thank you, Your Honors.
This honorable court stands adjourned until tomorrow, this afternoon. God save the United States and this honorable court.